Your Honors, good afternoon. Good afternoon, everyone. This is a continuation of the public panel interview of candidates for the position of Associate Justice of the Supreme Court, Vice the Honorable Justice Mariano C. del Castillo. Your Honors, for interview this afternoon are Justice Pablito A. Perez of the Court of Appeals. Sir, please rise. And Justice Maria Filomena Singh, also of the Court of Appeals.
Okay.
Can I administer the oath? Your
Yes,
Honors?
please.
Candidates, please raise your right hand so I will administer the oath. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the Judicial and Bar Council? Yes, sir. So help you God. Your Honors, the first candidate to be interviewed will be Justice Pablito Perez. May I request Justice Singh to stay in the holding room while the interview of Justice Perez is being conducted. Sir.
With the permission of my colleagues, may I ask to be permitted to shoot the first questions, like this morning. Good afternoon, Justice Justice Perez. Yes. Before you joined the Court of Appeals, you were in the corporate world.
Yes, Your Honor.
Okay.
Immediately prior to, yes.
Yes, and before that time, you were in the staff of Senator Rocco.
That's correct, Your Honor. I was in his law firm.
You were in his law firm. Law firm, you mean his law firm as his own or with ACRA?
I started in Accra, Mr. Chief Justice, and stayed there for almost 3 years. Then when Senator Rocco left to build his own firm, I joined him.
So you went with him because you idolized him.
Well, in a way, Your Honor, yes. I owe him a lot for my
Yes.
for
All
my
right.
legal career.
If you do idolize him, will you explain to us why he came to be known as the honorary woman?
Yes, Your Honor. I think Senator Rocco was a man before his time. Even before we have our many laws to protect the rights of women, Senator Rocco was already advocating strong protection for women. In fact, he was the father of women in nation-building law. And that is the reason why he was referred to as an honorary woman.
So is it valid for me to say that you would be in his footsteps? You would closely follow his footsteps. You would be idealistic, and you would be a Don Quixote in robes.
Most certainly, Your Honor, especially because our Constitution protects special classes of people, including women and children and youth and laborers. And I think it is our duty to make sure that the vision of the Constitution is followed.
Is that not going to disqualify you to a judicial position, since you are now stating a straightforward bias in favor of women?
No, Your Honor, it is, if I may respectfully disagree.
Is there not equality of the genders? Why are you saying that you would protect women more than men?
The Constitution says so, Your Honor, that the women is a protected class. And this is not an unreasonable
Is that true in your
classification.
household?
I think I need more protection, Your Honor.
Okay, anyway, the answer is obvious. You should really rally behind women because they have been discriminated against.
Yes, by tradition and by history, Your Honor.
Yes, and of the court levels in the Philippines, it's only in the Court of Tax Appeals and in the first level courts that women outnumber the men.
And if I may add, in law schools all over the Philippines, Your
But
Honor.
that's not a reason. Maybe they have more money to pay for tuition. Anyway, my point here, I'm going to this. You were in the corporate world and suddenly you got inspired to join the judiciary. You were appointed to the Court of Appeals, the second highest court of the country. Why this shift?
Your Honor, I have been in the academy likewise for a very long time. I have practiced law for almost 20 years. My corporate life was about 9 years. And I thought that after that career, I should spend the best years of my remaining professional life in the judiciary.
According to your personal data sheet, you were already receiving 350,000 pesos a month in your corporate in the corporate world. When you were appointed to the Court of Appeals, how much did you receive?
A little over, as I recall, Mr. Chief Justice, maybe about 100,000 in basic salary.
Okay, was that bigger than your corporate salary?
No, it was a lot smaller, Your Honor.
Okay,
It was a big-
why did you have to make that sacrificial leap? You don't usually do that. So something that is odd, as far as I'm concerned, is a valid point of curiosity for these kinds of investigations.
Yes, Your Honor.
Please explain yourself.
Thank you, sir. When I applied for a judicial position in 2014, my children were almost done with their college. I certainly did not think, Your Honor, that I would live the rest of my life making more money. Money is important only because we use it for good, but I do not think that I would like to spend the rest of my life just making more money.
Okay, I can grant you the benefit of the doubt, but here is the point. You lost 250,000 pesos
Yes, Your Honor.
by going to a lower paying job.
Yes, Your Honor.
The job was even more taxing. I
That's
assume
good.
so, because I've been also in that court before, and I knew what it took for one to earn a monthly salary there. You were appointed in 2014.
Yes, sir.
You have stayed up to now in that court. All right. Do you remember of one specific decision that you authored and had the concurrence of the other members of your division that you could be proud of and be boastful of today? One decision that is remarkable as far as your present recollection is concerned.
I have always, Your Honor, please, I have always tried to write the best decisions I can write. Some of them are good, some of them can be improved. I'm sorry, but I cannot.
So all of your
recall.
decisions are probably very good.
Your Honor, my commitment to myself is my decisions do not leave my room with my signature until
Okay.
I'm happy with it.
I agree with you on that. But now, let me go to the other extreme. Do you remember of any single decision that you ever regretted?
I have been reversed twice by
No,
the-
I'm not asking you about reversals. Regretted. For any reason.
Yes, Your Honor, I think there was one particular decision that I thought.
Tell us about it.
It was a family dispute, Your Honor, and it involved a compromise among parties that has already been judicially approved. The principal issue that came on appeal was whether I should enforce the compromise as judicially approved. I followed the precedents, I followed the rules on compromise and ordered it to be obeyed, the compromise as approved by the court. Unfortunately, Your Honor, it did not settle the dispute. In other words, the conflict continued to grow. And I think
No, what do you mean? The compromise was appealed? It is not appealable.
that is correct, Your Honor, and that is how I ruled. But the parties, or the other one party, was not satisfied with that ruling, and the, in the end, they asked me to inhibit from the case, and the I am saddened by that, Your Honor, only because we are here to settle disputes. We decide with the hope that there will be peace among the parties. It did not happen in this case.
Why?
Well, firstly, Your Honor, family cases are always difficult. Sometimes it's not just a question of law, it's not just a question of right or wrong, but
Okay,
there are other
going back to
issues.
that particular case, why did you regret it?
Well, I regret it, Your Honor, in the sense that maybe I could have ruled in another way so as to terminate the dispute between these family members.
And how did you rule?
I ruled by following precedents and law, Your Honor. The compromise was judicially approved. It was immediately final. It had partially been executed. And in my position, I thought I had no other choice but to uphold it.
Okay, after you approved that compromise or agreed with the trial court who approved that compromise, do you know what happened to that case? Was it ever brought to a higher court, or was it ever attacked or assailed by any of the parties for any reason?
No, Your Honor, I'm not aware of what happened.
So
to the
why,
case.
I don't see why you would regret. This part is very important as far as this inquiry is concerned,
Yes,
because you should be neutral as far as emotion is concerned.
Yes, Your Honor.
And that is the point that I am driving at. Why would you regret a decision that you thought was correct?
Maybe
If you did that, you would be unable to decide things, because you would always think about consequences that will never probably happen or occur.
Yes, maybe, Your Honor. That may be. I think you're correct. That at some point, when we have decided cases, then they remain decided, regardless of the consequences.
Okay, as of now, as of this time, how many decisions have you written for the Court of Appeals that merited the concurrence of your co-members of the division?
May I refer to
Yes,
the records,
yes.
Your Honor? During a 5-year period, based on the information of the Statistical Data Division, Your Honor, I've had 1,304 cases submitted for decision. And during that period of time, I have decided 1,058 cases, or a disposition rate of 81.13% over a 5-year period that I have been in court.
Is there a breakdown there between the criminal, the civil, and other kinds of cases?
This is just by total, Your Honor, but I have another report by the Judicial Records Division, and as of March 30, 2019, Your Honor, I have disposed of 341 civil cases, 165 criminal cases, and 490 special cases, Your Honor.
Okay, have you ever had any occasion to take part in cases involving the law firm of the late Senator Rocco?
The law firm dissolved, Your Honor, after the death of Senator Rocco, and the cases that came to me were handled by Attorney Capunan, a former partner of the law firm. I inhibited, Your Honor.
So up to now, you remove yourself from any case that might have had the participation of the former Rocco Law Office?
Yes, Your Honor. Well, not the law firm, Your Honor, but the partners. And so far, I have inhibited myself from cases being handled by Attorney Lorna Kapunan.
Our present rules require you to have had at least 10 years of separation from your former associates or affiliates before you could participate in any matter involving them. Hypothetically, you give us the impression, hypothetically, that you would inhibit whenever any of the former associates of Senator Rocco would have cases before you. Is that assumption correct?
Yes, Your Honor.
How would you find that out? How would we find that out?
I disclose, Your Honor. I disclose prior relationships, whether with my former law firm or with former law partners.
Okay, this morning I asked one of the interviewees about his take on judicial restraint and judicial activism. I appreciate his forthrightness in answering my interpellation, but as far as you are concerned, I don't know, I'm not aware if you were privy to what transpired between me and the interviewee, but let me put it to you bluntly. Are you aware of these two terms?
Yes, Your Honor, but not because of the interview this morning. I deliberately did not.
What do you understand by judicial activism?
My understanding, my limited understanding, Mr. Chief Justice, is that when the courts act not only to literally or textually apply a law or the Constitution, but that they interpret it in a manner that will give life to it, in a sense, to interpret more than what the letter says. And the danger with judicial activism, Your Honor, is to cross that very bright yellow line where it becomes judicial legislation. And I don't think we should and can do that.
So you would not like yourself to be an activist as far as cases that might require the court's intervention in policy?
No, certainly not, Your Honor. I think our constitutional duties and powers are well defined as a court. And we cannot inquire into policy, which is under the Constitution.
Based on your answer and on your present thinking, will it be correct for you to say that the court is not a political institution?
It's not a political institution, Your Honor, in the performance of its judicial functions, but it is a political institution because it is part of government. And whether we like it or not, Your Honors, the court will have to deal with the executive and the legislature.
All right. I partly agree with you that it is a political institution because it is a creation and it exercises sovereignty. Does that not bring you to a viewpoint that you should also be formulating policies because you are a political institution?
Not so, Your Honor. Section 1 of Article 8 is very clear about the extent of our power as courts. And we have been granted by the sovereign only the power to interpret laws, to resolve actual controversies involving legally demandable rights, and to determine whether there is abuse of discretion in certain cases. It is not our power, Your Honor, to make policy.
So your idea of judicial review is still the Marbury formulation? Well,
the formulation in Madison versus Marbury, Your Honor, is still sound law in the sense that our Constitution has defined three great co-equal branches. And I think it is necessary that each branch remains in its own defined sphere Otherwise, I think it will be very difficult for this government.
Okay, that power that is defined, judicial review, under Section 1 of Article 8, is it not largely also affected by that power that is granted under Section 5, Paragraph 5 of the same article?
Well, yes, Your Honor. The original jurisdiction of the Supreme Court under Section 5, Paragraph 5 of Article 8 tells us exactly in what subject matter and cases the Supreme Court may act. And the consistent and prevailing theory, Your Honor, is that it is not our power to inquire into wisdom, efficacy, or correctness of policy. It is only our power to interpret what the Constitution says and what the law says.
So if you would read the Constitution, you read it literally. That's your point.
Well, may I clarify my position?
Because you are using the word says.
Well, yes, Your Honor. May I clarify myself, Mr. Chief Justice? As John Marshall said, we are interpreting a constitution. A constitution is a live document. And our interpretation of the Constitution must run together with our present society, would run together with our present conditions. And therefore, in my mind, a purely textual interpretation of the Constitution in its black letter form may not result in what we desire for ourselves. If I may add, Your Honor, I've always thought, and this is my own feeling, that to me the most important part of the Constitution is the preamble, because that is where we define our aspirations and our visions as a people and as a country. And I think that when we interpret the Constitution, we do so to make real what our people's vision is of the government and the country that they want.
So by your answers, you seem to imply that you are not a textualist.
I don't think I am, Your Honor.
You are not a textualist. So you don't care about what the Constitution says. You only care about its preamble.
Not.
Is that what you meant?
No, Your Honor. If I may further explain myself, it's.
This is the point,
Yes, sir.
Justice.
Yes, sir.
If you keep on explaining yourself, you will never decide the case.
I have been,
No, I'm getting confused as far as your answers go. I think I deserve from you a more definite answer. Are you a textualist or what?
First, Your Honor, I think we are bound by the plain text of the Constitution when the meaning is very clear.
Okay?
But when the meaning is not clear, then we should be guided by the principles and the policies and the visions
Now,
in
if
our
you are not a
Constitution.
textualist and you resort to Black's dictionary or Bouvier's, do you mean to say that the Constitution should be read with Bouvier and Black by your side? What is it? What is it that you are trying to impress us on me?
Your Honor, if the dictionary of Bouvier and Black will help us to understand what the Constitution is saying.
But they were not enacted with the Constitution. They were older than the Constitution, and nowhere did the Constitution refer to Bouvier or Black. That's why I am interested to know how you would be a justice of this Supreme Court if you were to be given the blessing of the President after we shall have nominated you.
Yes, Your Honor.
That's why I do not like vague answers as far as these are concerned, because we will keep you to your promise that you are a textualist. If you are not, we will keep you to that promise also.
Yes. I don't believe I'm a textualist, Your
So
Honor.
what are you?
I think I would be a justice who would interpret a living Constitution without ignoring its letters.
So you would also be a justice with judicial activism guiding you?
Yes, Your Honor, to a certain
Did you
extent.
not say a while ago you do not like judicial activism?
What I think I said, Your Honor, is I would resist judicial activism if it will result in legislation. if it will result in revision or policy.
Okay. But you said also that we had the power of judicial review, and if the judicial review will result into revisionism, that's okay, is it not?
Well, Your Honor, if
Please be more forthright in your answer, because we do not have the whole afternoon for you.
my understanding of judicial review, Your Honor, is the power of the courts to render null a government act that is in violation of the
That's
Constitution.
the grave abuse of discretion clause.
So,
Is there a distinction between the first and the second sentence of Section 1 of Article 8?
the first sentence, Your Honor, says simply that judicial power is vested in one Supreme Court and other courts as created by law. The second sentence, Your Honor, says that the courts have the power to resolve actual controversies involving legally demandable rights and to determine whether there is abuse of discretion committed by any government agency or entity. So the
Okay,
first,
bringing you back to the,
yes, sir.
the curiosities that I had to express to you. Between judicial activism and judicial restraint, where are you?
In my case, Your Honor, I think the court should exercise judicial restraint.
Where are you? Where are you? I'm not asking about the court. I'm asking
I will exercise judicial restraint, Your Honor.
all the time.
Not all the time, Your Honor.
When will you exercise judicial activism?
When the circumstances and the conditions justify it, Your Honor, and the Constitution allows it.
When are those instances?
I think, Your Honor, a good justice will have to keep his eyes and ears on the ground and feel the pulse, the present conditions.
So you will be a flexible justice.
I will be flexible, Your Honor, only because my judgment will have to be rooted in the present. It will have to be rooted in facts that are available to me.
You know, in the adjudication duties of the court, we have what you call the writing of the main decision and the dissent, and then there will be an unavoidable motion for reconsideration. So you would allow yourself to flip-flop?
No, Your Honor.
But that seems to be the message you are saying.
No, Your Honor. I think I may have misspoken. What I wanted to say, Your Honor, is that when we decide cases, not only will we look at the letter of the law, but we will look at the spirit that gives it life, which means that our decision should be rooted in actual conditions, should be rooted in real issues and problems.
Okay, anyway, the philosophical reason for writing law is that the behavior or conduct that it should regulate invited the enactment of that law, and that law is universally applicable. It is not meant to change. It is not meant to be flexible. Do you agree with that?
No, Your Honor, because I respectfully disagree. I have another viewpoint. Law must develop. Law must grow.
You are talking about common law. I'm talking, we are in a civil law tradition where we have written laws more than any other. Or do you disagree with that?
Well, even in the case of statutory law, Your Honor, I think we must allow for a situation where Congress will pass a new law. If I may give an example, Your Honor.
No, we are talking about the work of a justice.
Yes, Your Honor.
We are not talking about the work of the Congress, because the work of the Congress is already done when we get the opportunity to pass upon that law and its application. That's the point that I'm making. When your turn will come to be that judge, to determine a particular dispute, okay?
Yes, sir.
You mean to say you will not be rigid in your reading of the law. You will read the law this way one day, and the next day in a different case, you will read it differently. That seems to be the impression that I get from your answers. Is that the impression correct or warranted?
No, Your Honor. I think what I meant was that I think if in a case the court reaches a point where the remedy lies in legislation or the remedy lies not in our judgment, then we must stop at that point, because then it is the power of Congress to make a new law if that is the remedy for that situation.
Okay, yesterday you took the exam. You took this exercise to write, yes, decision writing, and it's about same-sex marriage. Where are you on this?
Your Honor, I would like to be, at the moment, from what I know, I would like to be guided by the pronouncements of the Supreme Court in Ang Ladlad. Justice Del Castillo started by saying that people have a right to differ. And I think that we should be open to considering the possibility of a different kind of relationship to which, other than to which we have been accustomed to.
It's not only marriage.
Yes, Your Honor.
So what would you have in mind if it was not marriage?
Well, Your Honor, maybe a same-sex of marriage, of course, cannot happen unless there has been change in legislation, because the present letters of the present laws would not allow it. So
unless that law is amended, no marriage.
I don't think, Your Honor, that.
But is it possible to call it union?
Well, certainly, Your Honor, a relationship or a union, not as marriage as we know it in the civil code, I think is something that we should consider, because people have a right to associate themselves.
So if the court were to announce that a union could be had, is that legislation?
I think, Your Honor, if the court will say that a union of two persons of the same sex.
No, is that legislation? That's a question.
No, it's not, Your Honor.
It's not legislation.
I don't
So,
think it is a legislation.
You seem to be contradicting yourself again. If the court were to rule while you are there in the court that a union could not be the same as marriage, so it is allowed. There is no law prohibiting a union.
An informal union, yes, Your Honor, but not a marriage as we know.
Informal. Well, we are fencing. But anyway, thank you, Justice Perez, for your answers, although at some points you left me more confused than when I started. At any rate, good luck to your quest for this position of destiny.
Thank you,
Maybe
Mr.
it is
Chief
in your
Justice.
destiny that you might sit one day in the court.
Thank you, Mr. Chief Justice.
I now turn over the microphone to Justice Tiham. And colleagues, may I be excused? Huh?
Thank you, Chief. Good afternoon, Justice Pablito.
Good afternoon, sir.
Okay. You stated earlier that the Constitution is a living Constitution.
Yes, sir.
In what sense is it a living Constitution? Is it something that contracts? It is something that expands?
Your Honor, it is a living constitution in the sense that it is a constitution not written only for certain conditions. It is not a constitution that will govern only what is happening or at the time it was enacted. The U.S. Constitution, Your Honor, has been there for hundreds of years, and it continues to govern the lives of its citizens. And our Constitution, well, we have had an experience of changes in the Constitution more often. But the 1987 Constitution right now, Your Honor, is the longest Constitution we've ever had. And it continues to govern our lives. And therefore, I think that whatever the convention, the commission that drafted this Constitution could not possibly have foreseen the needs of society that are present now, could not possibly have foreseen the problems we have. And that is what I mean, Your Honor, that it is a living Constitution that we interpret in the court.
If you are in the Supreme Court and you are tasked to interpret a provision of the Constitution, will you be looking into something, even if it is not there, so long as it is implied in the text of the Constitution?
My duty, Your Honor, is to ascertain, to construe the intent of the provision as best as I can.
So if there's any ambiguity, what will be the next step? If there is an ambiguity, rather, what will be the next step that you will take in interpreting the Constitution?
Well, first, Your Honor, I think that the way we interpret the Constitution now is first we start with its letters.
Okay?
Because as I said, if the letters are clear and the intent is unambiguous,
Yes.
then it is our absolute duty to apply it the way it is written. Now, if there is some ambiguity about what a provision means, we refer ourselves to the journal of those that enacted it, because by referring ourselves to
But you
their
will not
discussions.
interpret it by implication. Will you interpret it also in a way that so long as it is implied from the text, you will interpret it that way, even if it does not appear expressly in the text of the Constitution?
If it is consistent, Your Honor, with the declaration of policy, the declaration of principles and state policies. In other words, Your Honor, if that implied interpretation is consistent not only with the letter of the Constitution, but also what the Constitution intends to bring about, then yes, Your Honor, I will do that.
All right. The Constitution provides that the President has one term of 6 years without re-election. Can the President run again after a break of 6 years?
My opinion is he may not, Your Honor, because it seems that the letters of the Constitution is
So
quite
you are
clear.
being a textualist in that sense.
Because, Your Honor, the letters of the Constitution appear to be clear. He may not. And I think an examination of the other provisions of the Constitution will help us understand that that is the constitutional intent. For example, Your Honor, the Vice President is not, the limits on the term of the Vice President is not worded the same way.
Now, a senator under the Constitution serves for a term of 3 years, and he can only run for, remind me, is it 3 terms or
My recollection, Your Honor, is 2 consecutive
2
terms.
consecutive terms? Can he run for a 3rd term under the Constitution?
The prevailing interpretation, Your Honor, is
No,
after.
what will be your interpretation if you were if that matter is raised to the court and it is assigned to you? Can a senator who has served and completed 2 consecutive terms, can he still run for a 3rd term?
I assume, Your Honor, that the question is, can he run for a 3rd term after
term.
a recess or after a break?
No, I'm just saying, after completing 2 consecutive, can he run for a 3rd term?
Not immediately, Your Honor.
The answer is no.
No, Your
That
Honor.
is proscribed All right.
I think so, Your
But
Honor.
after a break, can a senator run for another term?
The Constitution is open to two interpretations at that point, Your Honor.
Does the
Because
Constitution speak of a break?
it does not, Your Honor.
But why would you be open to interpreting something which is not expressly stated in the Constitution?
because of the word consecutive, Your Honor.
All right.
Because what the Constitution bars is for a senator to serve 2 consecutive terms, which suggests that he may do so for a 3rd term if it is not after 2 consecutive terms, which means he would need only a term break.
What do you think is the rational basis for barring a senator from running for a 3rd term after completing 2 consecutive terms? Is this designed to enable others to run for public office?
In all honesty, Your Honor, I'm not familiar with the journal on discussion on this particular provision. But from where I
But
sit,
if you
Your
were
Honor,
to interpret the provision of the Constitution, because it is specific, you can only run, if you're a senator, you can only run for 2 consecutive terms
yes, Your Honor.
and not a 3rd term. And yet, the practice is that senators who have completed 2 consecutive terms, after taking a break, still runs for another term. But the Constitution does not speak of a break period.
That's right, Your Honor.
So if that issue is raised before the court and it is assigned to you, how would you interpret that? Will you allow that senator to run again for another term after a break?
My personal position at this point, Your Honor, is maybe not, from where I sit. And the basis of my opinion at the moment is the policy of the Constitution is to open up the opportunity for public service. And we know likewise, Your Honor, that the discussion on term limits in the Constitution, in the Constitution, with respect to certain offices was precisely to avoid permanence of the same persons holding public office.
If Congress passes a law legalizing the sale and use of marijuana, and a case is filed before the Supreme Court questioning the constitutionality of that law, how would you decide the case?
I'm sorry, Your Honor, but I don't think I can hazard an opinion at this point on that particular issue, only because I don't have knowledge about marijuana or its effects. I would like to have more information, Your Honor.
Should a judge therefore abstain from deciding a case because he has no real-time experience about the matter in issue?
No, Your Honor. If I were a trial judge, I will demand evidence.
Yeah. But if you are in the Supreme Court, and the issue before the court is the constitutionality of a law passed by Congress legalizing the sale and use of marijuana, will that law, to your mind, in your valued judgment, be considered constitutional or unconstitutional?
I cannot at the moment, Your Honor, recall any constitutional provision that will be offended by a law that allows the sale of marijuana. Of course, the present state of law under Republic Act 9165 considers marijuana as a prohibited drug, and therefore it is an illegal substance. But there is nothing in the Constitution that bans it. And therefore, from that point of view, Your Honor, I think the constitutionality challenge may not be strong enough.
The Philippines withdrew from the ICC, and the government announced that it will bar the entry of ICC investigators will come to the Philippines to investigate President Duterte for alleged crimes against humanity. The government also announced that it will bar the departure of any Filipinos who will seek to participate in the investigation abroad. Are these actions constitutional? An action of the government that will bar the entry of ICC investigators who would like to come to the country to investigate alleged crimes against humanity, would that be constitutional?
With respect, Your Honor, to preventing entry by the representatives of the ICC in the Philippines, that is our sovereign right, Your Honor. That is an absolute right.
You think it's a valid?
It is valid, Your Honor.
It's a legally
it is a
permissible
legally.
and a constitutionally.
I think so, Your Honor, because the state has an absolute right to decide who it will allow who it will receive or allow to enter its
What
territory.
about the action of the government to bar the departure of Filipinos?
I think, Your Honor, in that case, I may have to disagree because the Constitution protects the right of citizens.
What is a precautionary whole departure order, Your Honor?
Your Honor, precautionary whole departure order is an order that is issued by courts to disallow or prevent the departure of certain persons charged or about to be charged of an offense.
With the withdrawal of the Philippines from the ICC, is President Duterte immune from accountability?
I'm sorry, Your Honor, I have to admit I have little familiarity with the Rome Statute at the moment.
But there is a law, a Philippine law, that allows the prosecution of crimes against humanity, genocide.
That's correct, Your Honor. We have that law which punishes crimes which are also punished by the Rome Statute.
Can the president be investigated for alleged crimes against humanity, genocide, under Philippine laws?
I think after his term, Your Honor, he may be.
He's immune from suit, but thus immunity from suit connotes that he cannot be investigated while still in office.
That's correct, Your Honor.
Are you familiar with the law on public bidding, Justice Fabrito? What is a Swiss challenge?
Swiss challenge, Your Honor, is when an unsolicited proposal is received for a government project, and the government accepts it as a proposal by recognizing the proponent as the original proponent. Our laws require that his proposal, before it becomes contract, should be open to a Swiss challenge, which is a bid by others for the same project. And the original proponent will have the right to outbid again that person who bidded for the project.
As a person, do you consider yourself a solo achiever or a team player?
I function effectively in a team, Your Honor. I know my role. I know when I must contribute, when I must listen, and when I must
What is your
object.
attitude if
But-
the people with you appears to be far more superior than you are?
Then I will listen and learn from them, Your Honor.
And what is your attitude if the people around you are, to your mind, far more inferior than you are?
Then I will sit in silent respect for them, Your Honor.
What is your understanding of the collegial nature of the Supreme Court?
Well, constitutionally, Your Honor, the Supreme Court sits either in bank or in divisions of 3, 5, and 7, depending on the rule of the Supreme Court, which means that the decisions of the Supreme Court is not the decision of one justice, but it's a decision of the division or the en banc, depending on who rendered the ruling. But more importantly, other than these formalistic requirements, Your Honor, I understand collegiality to mean that members who sit in the same division or in the en banc will benefit from each other, and that this contribution of ideas, even ideas which are conflicting, will clarify and help reach us and help reach the most fair and the most just resolution.
Is judicial legislation constitutional?
It is not, Your Honor.
When the Supreme Court promulgated its decision on the condonation doctrine, was it a case of judicial legislation?
I do not think so, Your Honor. I do not think the court was legislating.
What is your understanding of the condonation doctrine?
My little understanding, Your Honor, is that a public officer who is publicly charged and who is re-elected for the same position.
You're talking of an administrative case.
Yes, Your Honor. Can no longer be charged again for an offense he committed in his previous office.
Because
Because
offense is condoned.
by being re-elected, Your Honor, by the sovereign returning him to office, is manifestation that he has been condoned or forgiven.
So you said it is not a case of judicial legislation.
No, it's not, Your Honor. I do not think it is.
Is there a statutory basis for the condonation doctrine?
No explicit statutory
Is there a
doctrine.
constitutional basis for the condonation doctrine?
I would root it, Your Honor, the principle of condonation. I will trace its roots to the sovereign, to the right of the sovereign to choose their leaders, and therefore, if they choose to elect again somebody who has been charged with an offense in his previous office, and they elect him again, I think the right of the sovereign to choose him is the root of this doctrine.
So you're saying the Supreme Court did not commit a mistake when it promulgated a decision on the condonation doctrine?
I do not think so, Your Honor, and the court...
Why did they abandon it?
Yes, Your Honor,
If
I
it was
think
not a mistake.
when the Supreme Court abandoned the condonation ruling in Carpio Morales, Your Honor, versus Binay, I think there was a change of perspective in the sense that the allowance of the condonation doctrine suffered from what I call the law of unintended consequences. And while the doctrine of condonation previously defined is an expression of sovereign will, that expression of sovereign will has been abused to allow people to use it as a subterfuge to commit irregularity in public office.
All right,
Yes.
one last question. Can a Pasig commercial court issue a search warrant enforceable in Cebu City for criminal actions for violation of the intellectual property rights under the IP code?
If I recall my rule on search warrants, Your Honor, I
Under
think,
the intellectual property.
yes, Your Honor, if I correctly recall my rule on search warrants, a search warrants in connection with intellectual property law violation may be issued by the executive judge.
But can a Pasig commercial court issue a search warrant enforceable in Cebu, in the Visayas, for intellectual property violations?
I may be wrong, Your Honor, but my recollection seems to be yes. together
can
with
be
some.
enforced nationwide. Okay,
Yes,
thank
Your
you
Honor.
and good luck.
Thank you, Mr. Justice.
Thank you very much, Justice Tiham. Judge Ilaw.
Yes, thank you, Justice Mendoza. Yes, good afternoon, Justice. How are
Good
you
afternoon,
today?
sir. I'm fine, sir. Thank you very much.
You have been with the Court of Appeals for only 5 years.
Since March 13, 2014, Your Honor.
Do you think you have served the court fully in that span of time?
Yes, I have, Your Honor.
Why do you say so?
Your Honor, in terms of, well, quantitatively, in terms of the work I have done, I think my disposition rate and my case disposition average will say that I work very hard in that job, Your Honor. And more than that, Your Honor, I would like to say that those 5 years have been years that I've spent learning the functions of judging.
Are there programs you spearheaded which greatly improve a process or system in the Court of Appeals and which could be attributed solely to you?
No, Your Honor. None. I'm sorry.
And because you mentioned about being a team player.
Yes, Your Honor.
You listed about 27 cases that you failed to decide within the reglementary period. Am I correct?
Yes, Your Honor. I enumerated that in the PDS form. And if I may say, Your Honor, the last time I checked, that has been reduced to 12.
And to which factor do you attribute such failure to do so?
Your Honor, it's really just a question of volume. When I was transferred to Manila, my initial caseload was almost 600 cases.
You have quite a few pending administrative cases. Am I
Yes, Your
correct?
Honor.
This is an admin case relative to CAGRSP number 151313 filed by a certain Restituto Ingal
Yes, Your Honor.
on February 20, 2018,
Yes, Your Honor.
and still pending.
Yes, Your Honor.
Abuse of authority in affirming the decision of the Civil Service Commission filed by a certain Nestor Dizon, August 8, 2017, still pending.
Your Honor, if I may beg.
The complaint was referred to the OCA.
Your Honor, my own recollection is the administrative complaint involving Mr. Dizon, where I was sued as a member of a division because the ponente there is, I recall, PJ Barza, has already been dismissed by the Supreme Court, Your Honor. The case of Mr. Ingal, on the other hand, yes, Your Honor, it is still pending.
About this letter of request of William Gilani for investigation on the conduct of Honorables Camelo, Badiles, Martin Inting, and Perez, filed on January 31, 2017. Still pending.
Yes, Your Honor, it's still pending, and if I may be allowed to say a little, to explain the background. That case, my only participation in that case was to concur in the issuance of a temporary restraining order, which gave rise to another administrative case that has already been dismissed by the Supreme Court. This pending second complaint against 5 other justices in Cagayan de Oro, Your Honor, raises principally the issue on the allowances of the justices being received from Cagayan de Oro City because the litigation involved the incumbent mayor at that time. And Mr. Giuliani charged 5 justices of 9 justices in Cagayan de Oro of acting unjustly, primarily because, according to him, we were receiving allowances from the city.
Mind you that the council, however, prefer applicants with no pending cases.
Yes, Your Honor.
Why should you be an exception to the preference?
I think, Your Honor, that these two pending cases on their merits are clearly, well, these two pending administrative cases are, to my mind, Your Honor, with respect, clearly without merit. And the only reason they are still pending is, I think, because court is seriously reviewing before making a decision on this. And it is my view, Your Honor, that the disqualification by reason of pending administrative cases by this Honorable Council will consider grievous cases, say, of graft and corruption, bribery, immorality. These are the disqualifying cases. On the other hand, Your Honor, this type of cases where a justice is accused of doing wrong because of his decision in the course of the performance of judicial functions, I do not think, Your Honor, that this is valid ground to disqualify a justice from applying for another position, because we all know very well, Your Honor, that this is part and parcel of the duty we perform every day. In fact, Your Honor, one thing I've learned in my tenure in the Court of Appeals is with every decision I write, I make only 50% of the world happy. The other 50% becomes my enemy.
This letter of request of William Gelani
Yes,
in
Your Honor.
relation to the alleged justice for sale.
That's correct, Your Honor, because he alleged, and it is true, that the justices in Cagayan de Oro City are receiving allowances from the city. And if I may explain my position on this matter, Your Honor. First, Section 458 of the Local Government Code authorizes the city, if its finances permit, to provide additional allowances to judges, prosecutors, and national government officials who are located or working in the city. Secondly, Your Honor, the allowances being granted by the city of Cagayan de Oro is duly covered by an ordinance passed by the City Council. And if I may add, Your Honor, that ordinance was passed by the mayor who was the predecessor of the mayor who was in charge in the litigation. And so, legally, Your Honor, I have no question in my mind that the appropriation by the city of additional allowances for the benefit of national government officials serving in the city is not unlawful. But I will concede, Your Honor, that maybe there is an optic problem, there is a perception problem, and maybe it will be correct if the Supreme Court will have oversight functions over these allowances, just to negate this perception that the city can give us benefits in exchange for judicial favors.
All right, this is aside from such rumor of that the seems to be the perceived conflict between the functions of the Court of Appeals and the Ombudsman on the matter of temporary restraining order issued in relation to the dismissal orders by the Ombudsman against government functionaries. How would you characterize the current state of the Court of Appeals?
When the temporary restraining order was issued in connection with the Moreno cases, Your Honor, in CDO, the Supreme Court has just handed down the ruling in Carpio Morales versus Binay. If we recall that ruling, the Supreme Court said that the provision in the Ombudsman law that says the ruling of the Ombudsman cannot be restrained except by the Supreme Court was rendered unconstitutional. And in the case of the Moreno cases, Your Honor, when that came to us, I personally, and this is the reason why I concurred with the issuance of a temporary restraining order, is I perceived at that time a serious question of due process, and I wanted time to carefully study the case. And we may also recall, Your Honor, that the Court of Appeals issued a temporary restraining order in the Binay case, which was the subject of that ruling. And the Supreme Court also affirmed the validity of that order.
Do you believe that there is corruption in the judiciary?
Yes, Your Honor.
What measures would you propose to minimize, if not to eliminate, that problem if and when you're appointed as an Associate Justice of the Supreme Court?
All I know at this time, Your Honor, is that, well, let me start by saying, Your Honor, that after 5 years, I came from the private practice. When I came to the Court of Appeals, my viewpoint was, like most lawyers, that the court is a place of deep distrust. After 5 years, Your Honor, I'm happy to say that my impression of the court and judges and justices and court workers have changed. I have seen judges, justices, court workers who do their duty honestly and with diligence, sometimes under very hard conditions. But that said, Your Honor, there are still those problems of what we refer to as corruption. And I think it is not something that is only in the judiciary. It is in other government offices. It is even in private offices. Now, you ask me, Your Honor, what would I do to resolve it? I'm sorry, Your Honor, but at this point, I really would not have any idea how to start solving it. All I know, Your Honor, is that to get it resolved, the courts, the lawyers, and everybody else who respects the judiciary and desires the judiciary to perform its duties as well as it can, it is the duty of everybody to cooperate in whatever needs to be done to correct this.
All right, thank you. And could you explain the discrepancy of your peso deposits in your SAL-end? It's about 2,655,000 vis-a-vis your PDS declaration as against 5,178,667. Can you refer to your records ng PDS?
Yes, Your Honor. May I have your question again, sir, please?
A discrepancy of your peso deposits in your SAL-end compared to your PDS declaration.
I'm sorry, Your Honor, but the PDS declaration and my SAL-end appear to be more or less consistent. If there is any differences in amounts, it's because these amounts are moving on a moving because they're being used.
Because you have a deposit of 17,000 US dollars?
That is correct, Your Honor. I have declared it in my SAL-end and in BPI Family Bank. It is in Family Bank. It is a deposit that I have maintained, I think, for maybe 20 years already.
All right, again, you've been a justice of the Associate Justice of the Court of Appeals. Could you expound on one accomplishment that you consider your best, that makes you worthy of a seat in the High Court?
I think, Your Honor, I cannot refer to any one particular achievement, as you may call it. What I can say, however, Your Honor, is I am very proud of the work I do in the court. By the decisions as drafted by my lawyers, they are reviewed 3-4 times before we finalize it. I am pleased, Your Honor, that my lawyers tell me that they learn from me, that they learn from the way I review their work. And I think that is what I am proud of, Your Honor. I cannot think of a single thing I have done. But on a day-to-day basis, Your Honor, I have done my work to the best I can.
Believing that you belong to RoboCop, Rocco,
Yes, Your Honor. That was,
Wanuan, Kapunan, and
Yes.
the last P, was it Perez or what?
yes, Your Honor. When Senator Rocco left Accra and formed his office, there were 5 of us. Senator Rocco, Commissioner Bunyag, Attorney Kapunan, Attorney Megalios, and myself. And initially, we were referred to as RoboCop.
All right. If today were to be your last day on earth, how would you spend it?
I'll spend it with my family, Your Honor.
Why?
They are
Family?
Yes, Your Honor. Because they're the last people I want to see when I close my eyes.
All right, thank you. And thank you for time and effort, and good luck to your journey. Justice.
Thank you, Your Honor.
Thank you very much, Justice Perez.
Good afternoon, sir.
Afternoon. Earlier, you mentioned that you were reversed twice by the Supreme Court.
Yes, Your Honor.
What were the issues there, factual or legal?
These were 2 drug cases, Your Honor, and I was reversed in the first case on chain of custody issue, on the question of a proper inventory after a buy-bust. In the second drug case, Your Honor, it was also a drug case. I was reversed on 2 issues. First, the issue was again on a Section 21 ruling. It was a factual determination of compliance with the Section 21 requirement of Republic Act 9165. And I was also reversed on the issue of whether an actual sale has taken place of the drugs involved in the buy-bust.
Just in the appreciation of the evidence, records, right?
I would think so, Your Honor, please. Yes.
What is your judicial philosophy?
My judicial philosophy, I think, Your Honor, is that the courts have a well-defined constitutional duty, and every decision of the court should be guided by the Constitution, and that if we remain faithful to what the Constitution says, then our decisions should give life to the principles and the policies that are well defined in the Constitution, Your Honor. Like social justice, Your Honor, like protection of disadvantaged classes of people.
Are a judicial activist?
Well, I suppose, Your Honor, if that is what it takes,
You're
yes.
a believer in living constitution
Yes, I am, Your
that
Honor.
should be interpreted in accordance with times.
Yes, Your Honor, without changing its letter or intent, to the extent we can, yes.
earlier mentioned that senator cannot run third consecutive term, correct?
Yes, Your Honor.
There must be a gap after the second term.
In my response to the question of Justice Tingham, Your Honor, I advance the view that even after a break, I think the spirit of the Constitution should disallow a third term.
There is a break between the first term and the second. The third term allowed, which is consecutive.
That's a different situation, Your Honor.
Yes,
Then
that's why
obvious-
I'm asking.
Yes, Your Honor. In that case, there are no two consecutive terms because the first term was as broken. After the first term, there was a break. Then the senator can serve two consecutive terms. As Justice Tingham observed, Your Honor, there is no clear prohibition in the Constitution on serving a third term.
Suppose in the first term, the senator won, but another candidate was proclaimed, so he filed a protest, referring to the Senator Pimentel case.
Yes, Your Honor.
So he was first elected in 2007, but assumed only in 2011. After winning his electoral protest against Senator Subiri, 2013, he won a second six-year term. Senator again ran for the third term, arguing that he did not fully serve the first term. The Comelec decided that he was allowed to run. Should you be appointed to the Supreme Court and the case is brought before you, what will your position be?
To my recollection, Your Honor, if I will apply what I recall to be the prevailing rules, the term must be completed, or if it not completed, it must be by reason of a fault, or it must be by a cause or reason not attributable to the candidate or to the official. That is, I may be wrong, but Your Honor, but that is my recollection. And in this case, in the case of Senator Pimentel, obviously it was not his fault that he had to serve only the remainder of his term after he won his protest. So, in that sense, he did not have a completed first term.
You do not complete the first term. A term, I mean to say you do not complete. And your actual service was cut short.
Yes, Your Honor.
What do you call that?
I'm sorry, Your Honor, it escapes
Okay,
me
what
right
is the
now.
difference between tenure and term?
Tenure, Your Honor, term, Your Honor, is a fixed period. Tenure is the actual period above the occupied by the officer.
So you can have in the case of in the case of Senator Pimentel, served the first term. He served, but he was not able. He only served for 2 years.
Yes, Your Honor.
Can he be considered to have served the first term because he was elected in 2007 and was allowed to sit 2011?
My recollection of Senator Pimentel's case, Your Honor, is he was allowed to sit for the remainder of the term after Senator Subiri was removed, and the court, and there was a resolution that Senator Pimentel actually won that election. Now, to the question, Your Honor, was serving the last 2 years of the remaining term a service of the full term? I don't think it is, Your Honor, because the Constitution says that the senator shall serve for a term of 3 years. Oh, 6 years. I'm sorry, Your Honor.
Have you come across the case of Geo Samar?
Yes, I have, Your Honor.
What is the filtration approach?
The case of Geo Samar, Your Honor, decided March this year, re-emphasize and stress two important principles. First, the hierarchy of courts, and second, that the Supreme Court is not a trier of fact. As the opponente, Justice Ardilesa, explained, Your Honor, these two principles must be strictly followed and must be observed by all lawyers, because this is the way by which the Supreme Court, to use the term of Justice Ardilesa, filters the cases that it will consider and decide. I believe, Your Honor, that I was happy with the decision of Geo Samar, Your Honor, because that confirms that the Supreme Court has an agenda-setting function or power, that it should be able to decide only the cases which it thinks is worth, because the issues are substantial and because there are no factual issues involved, and therefore it will help in the end to unclog the docket of the Supreme Court. And I think also, Your Honor, I agree completely with the ponencia that litigants and lawyers should now begin to realize and accept that the recourse to the Supreme Court is the last resort, that the trial courts and intermediate appellate courts are competent to rule on disputes, and therefore an attitude that until the Supreme Court speaks, I don't know what the law is, I think is not helpful, Your Honor, to solving this problem of delay and clogged dockets.
The Constitution, President and other officers named there may be impeached for culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. What is betrayal of public trust?
As I recall, Your Honor, in the case of Francisco, the Supreme Court restrained from defining betrayal of public trust because it is a political question as a ground for impeachment. As we know, Your Honor, impeachment is a process solely within the exclusive jurisdiction of initiated by the House and to be tried by the Senate. And therefore, the interpretation of betrayal of public trust as a ground for impeachment should, under the Francisco's case, be left to the definition to be made by these two houses.
What was the interpretation of, or reason given by the framers for including betrayal of public trust? Did it be tantamount to a criminal act?
No, Your Honor. My recollection is no. It is not the crime of treason as defined in the revised penal code. It's more of a grave disloyalty, as I understand it.
Mentioned earlier, I was just curious. Why do you consider 50% of losing litigants your enemies?
Only, Your Honor, I said that only because to the party who is favored by my decision, they think that I am the most brilliant justice in the Court of Appeals. The party who lost, I am the most ignorant, if not the most corrupt. I have come to accept that this is part of what we do every day, Your Honor. And I comfort myself by saying, well, if the referee in a basketball game, they throw bottles and coins at the referee in a basketball game and only a game is at stake, then I understand, Your Honor, because when we do our functions as justices and judges, life, liberty, and property is at stake. Sometimes even honor, Your Honor. So I guess that's what I meant, Your Honor.
What you said was merely an exaggeration.
Yes, it is a hyperbole, Your Honor.
Yes. That will be my last question.
Thank you very much, sir.
Justice.
May I ask for leave, Your Honors? I'm sorry. Thank you, sir.
Thank you, Justice Perez, and we wish you good luck. Your Honors, the last but certainly not the least candidate to be interviewed today is Honorable Justice Maria Filomena D. Singh of the Court of Appeals.
Justice Singh,
Thank you, Justice Mendoza. Yes, good afternoon, Justice.
Good afternoon.
How are you today? You seems to
Very
be relaxed.
nervous.
Mukhang chill na chill ka.
No, I'm actually very nervous, sir.
Let's start. What is your story?
Everything?
Yes.
Okay. Well, I started out as a private practitioner, Your
Okay.
Honor, and I stayed in the firm, the first firm, for 3 years, and then we decided to set up a new law office. I joined that new law office, and I stayed with them for another 6 to 7 years. But even as early as my 7th year, I felt a dissatisfaction with practice. I felt I did not feel any sense of self-fulfillment. My feeling was that I was doing a job and I was just getting paid for it. And so I started talking to my friends, and one of them is my mentor in the law firm. And he told me that what is the source for this dissatisfaction. And I said, Your Honor, that it's difficult to predict how cases turn out because sometimes we are puzzled because we believe in the merits of our cases and yet we still lose our cases. And so he said that why don't you try to do something to change what you think is wrong with the system. And I told him honestly that how could I possibly affect any change? I'm just one lawyer in a country of thousands of lawyers. And so he said, then if that is your attitude, then nothing will ever change. And that got me to thinking. And so I thought that, Your Honor, maybe if I experimented in a controlled environment like one court where I am the judge and I control the proceedings, I could try some things that could help affect some of the changes that I was, dreaming of. And that's why I decided to apply with the judiciary. And that's the short version of it, Your Honor.
All right, thank you. Can we go private?
Yes, Your Honor, but I think my 4 children are watching.
Because in your PDS, as the name of your spouse, it's NA, position, occupation of spouse, NA, agency office, NA. I still remember one of the applicants then, when asked about such status, what's the meaning of NA? He said, is it not applicable, not available, no attachment?
Your Honor, my marriage was annulled back in 2004. And since then, I have been single.
How blessed is singleness, Justice?
Very blessed.
With no interference from husband, in-laws, more particularly mother-in-law?
No, since the annulment, no more in-laws to speak of.
Okay. All right, you were required yesterday about the decision writing. And during the alleged or seemingly written examination, you remarked that you are, and I quote, like kindergarteners. What exactly do you mean by that?
Oh no, Your Honor, just the fact that we all went there, we were accompanied by our respective members of our staff, and we brought our food, we brought our water, and then when we were taking the examinations, our staff were waiting outside, like kindergarten children. The caregivers or the parents are waiting outside, and when then you go out and they are going to welcome you and escort you home. That's the only thing that I related to being like kindergarteners.
But do you agree with the new process by the JBC of requiring applicants? Just a test of knowledge, intelligence, skills, job description.
Definitely, Your Honor. I think it is a very, very good innovation because, after all, one of the main tasks that we will be taking on if we do get appointed to the High Court is to draft decisions on a daily basis. And so an assessment of the decision writing skills of the applicants is very, very important.
Alright, you stated in your application letter that you work on several reforms to address the issues on docket congestion and case delay. What exactly is your participation in these reforms?
Thank you, Your Honor. The first reform project I worked on, Your Honor, in Quezon City, I was still in the Metropolitan Trial Courts at the time, was the original Rule on Small Claims project. This was during the time of Chief Justice Renato Puno. And we, together with other judges from the Metro TCs, drafted the original rule on small claims. We drafted the templates, Your Honor, for the very first time. We had templates for all the papers that will be used in a small claims proceeding. We also drafted the administrative rules for the executive judges and the branch clerks. Your Honor, small claims has proven to be a great docket reducer. The Metro TCs, the municipal trial courts nationwide have had a consistent success rate in their small claims cases of in the high 80s since we launched this project back in the time of Chief Justice Puno. And up to this date, it has undergone 2 revisions already, Your Honor, under the auspices of Justice Peralta, where they increased the threshold for the small claims. We started with 100,000. Then the group of Justice Peralta now have increased it twice already. because of the success of the small claims project. During my time, Your Honor, when I joined the MTC in 2002, the average docket of the MTCs at the time was 2,500 to 3,000. In fact, I myself inherited a docket of 5,000 cases. But now the dockets of the MTCs are down to an average of 900 to 1,200. So that project in particular, Your Honor, has greatly helped reduce the dockets of the first level courts.
Alright, going over the records of yours as well as the requirements, the application, there is an administrative case, gross incompetence and ignorance of the law and procedure, partiality and unreasonable delay in rendering decision and disposition of motions by certain Mariano Town. Actually, it was dismissed, but yet with a warning to be more circumspect in the exercise of her duties. You top in my list with about 8 administrative cases. What do you attribute this? Is this a reflection of how you preside and how you work as a judge and also as a justice?
Not necessarily, Your Honor. I was at the time a very and all through my tenure as a trial court judge, I was very active. I was very proactive. I really controlled the proceedings and I really introduced a lot of innovations, Your Honor. And perhaps some of these innovations did not sit well with the people or the court users, and maybe they took issue with some of these. But I can assure Your Honor that in all those cases, not one of the innovations that I introduced was found by the Supreme Court to have been done in excess of my authority or in violation of any rule or law, Your Honor. In that particular case, if I may expound, in that particular case of Attorney Tahon, if I remember correctly, Your Honor, it was because of a motion that was not filed in the actual case folder, and that was found among papers that were kept in the custody of the former branch clerk, and which were only unearthed after that former branch clerk had left the court already.
How are decisions reached in the Supreme Court?
Your Honor, by deliberation is my understanding, and from a reading of the internal rules of the Supreme Court, there will be deliberations first before a member is assigned to study the case and to prepare a draft. And then once a draft is prepared, I think it is circulated again to all the members, either of the division or the en banc, for further comments. And if there are no more comments, I think that's the time when the draft will be finalized for signature.
Section 13 of Article 8 of the Constitution provides the conclusions of the Supreme Court in any case submitted to it for decision in bank or in division shall be reached in consultation before a case is assigned to a member for the writing of the opinion of the court. There are still pending cases involving the doctrine of condonation that transpired before the doctrine was abandoned by the court in 2016. Are you aware of this?
Yes, Your Honor. There are several cases, I believe, pending in our court now, the Court of Appeals.
For these cases, may the court apply the doctrine of condonation in favor of elected public officials motu proprio?
Motu proprio, Your Honor. There has to be a case filed in court involving that particular principle, Your Honor, for us to be able to apply it.
Do you remember what case is that?
Your Honor, the ones that are pending.
No, in the case of the court, in what case?
Well, I can speak of a case that we decided, me as a member, I was not the ponente. It was a case involving the former mayor of Makati, Junjun Binay. And the condonation principle was at issue.
What's the first thing you wish you had done at this point in your life? And why haven't you done it yet?
I wish that I had written more short stories because that was my undergraduate course. I was a major in imaginative writing at the University of the Philippines, and I was really set on becoming a fiction writer, Your Honor. I was apprenticing with Francisco Arceliana, the national artist, but then law school intervened, and I did not have time to write fiction anymore. But in the past, probably in the past 6 or 7 years, I've gone back to writing short stories, and I'm trying to collect all my short stories to come up with my first ever publication. I need 10 to publish a collection of my short stories, so I'm short by 2 stories right now, Your Honor. So that's what I want to do, which I have not done yet.
Are you close to Senator Pacquiao?
I will have to say that he is a friend.
About his friend?
He has many friends, Your Honor.
A particular friend?
He has many particular friends, Your Honor. But I'm very close to the senator, and this dates back to the time when I was still in the trial courts, Your Honor.
All right, my last question will be this. One morning you woke up and found an elephant in your backyard. What are you going to do?
I think the first thing I'll do is take a picture with the elephant, Your Honor. But I will wonder how the elephant got there. That's the first thing. What is it doing in my backyard? How did it get here? And to call the proper authority so that the elephant will not be exposed to any undue injury also.
All right, thank you very much. That was my last and final question, and good luck.
Thank you very much, Your
Justice,
Honor.
on your journey. Man.
Thank you very much.
Thank you very much, Justice Tiham.
Thank you, Mr. Chairman. Good afternoon, Your Honor.
Good afternoon, Your Honor.
How would you differentiate judicial demeanor from judicial temperament?
I think judicial demeanor, Your Honor, is the overall comportment of a judicial officer. It's the way that you carry yourself, not only in court, but everywhere that you go. Judicial temperament is not temperament as in temper, but I think it is how you handle things orally and in writing, which tend to inflame passions. It's how you rein in your biases and prejudices, how you rein in your personal opinions, and how you do not allow your emotions or your passions to get the better of you in adjudicating the cases before you.
What kind of judicial demeanor would you like to project to the court, to the litigants, and to the public?
Of course, Your Honor, I always strive to appear impartial and neutral and always independent, Your Honor.
So what kind of judicial temperament would you like to display to the other members of the court if you are appointed to the Supreme Court?
That I am level-headed, that I am also open-minded.
If you feel strongly about a particular issue or a particular case assigned to you, and you are the ponente and you circulate it, you submit it to the other members of the court, and there are dissents, reflections, comments, adverse reaction from the other members of the court, what would be your attitude?
As I have already been doing, Your Honor, in the Court of Appeals, if I receive a note or a comment like that, I go immediately to my colleague and I try to discuss it. I try to elicit more from him or her so that I will understand his perspective. And if I see that his perspective is valid, then Your Honor, I never think twice. I'm always willing to change my work if I see that there is a valid point that I failed to take into consideration. But if I see, Your Honor, that the point that is being raised is not valid, then I will be firm in maintaining my position.
So you will not relent or accommodate a dissent, for example, if you feel strongly about your position.
Actually, Your Honor, I don't think I have any choice if anybody wants to register a dissenting opinion. But I can try to avoid that situation by going and talk to the person who has registered a dissent and trying to explain my position. Maybe in my first draft, I did not explain my position very well. And I might be able to convince that person if we talk about it at length. And maybe some revision to my draft can also convince that person not to register a dissent anymore. But if having exhausted all those means, the other person still wants to register a dissent, then I think that is his right under the rules. But I will certainly respect his opinion because after all, it is his opinion, as my opinion also is something that he has to respect.
Are you a team player or a solo achiever all your life?
Your Honor, I think my record in reform will show that I am a great team player because I would not have been able to accomplish a lot in terms of the reform projects that I've done for the court if I am not a team player. This entailed the cooperation of the other judges, the court personnel, the people in the Supreme Court, and our friends, the donors. And if I were not a team player, I would not have been able to do any of those things, Your Honor. Now, in terms of work in the court, the adjudicative work, Your Honor, the greatest challenge to me when I was promoted from the trial courts and to the Court of Appeals was the collegiate nature of the court, because I'm a very opinionated person, and that to me was going to be a challenge. But I have not really found it very difficult, Your Honor, to adjust to my work in the Court of Appeals, because as I said, if ever there's a comment, I really go out of my way to try and talk it out. And in the same manner, if there is something that I see in the work of my colleagues and that I do not agree with, I write a note. Your Honor, I do not immediately register a dissenting opinion. I try to write a note if I see that the other member may still be convinced, Your Honor.
There are certain protocols, rules of conduct followed in the Supreme Court, like the seniority rule
Yes.
and others, you have to defer to. But if during the deliberation of a particular case, you strongly disagree with the position of the Chief Justice, what would be your attitude? Or with the position of the senior justices of the court, what would be your attitude?
Your Honor, if I really strongly disagree, I would have to make known my reasons for disagreeing in a very courteous and respectful manner, Your Honor. If it can be done privately, not during the open deliberations, then I will try to do that. If not, then I have no choice but to air it
Why
out.
would you do it privately?
Your Honor, if...
That will defeat the collegial nature of the court. Is it necessary that you bring out your position, your strong position about a particular issue under deliberation before the bank?
Your Honor, I was thinking of a situation where, for example, what I strongly disagree with, for example, is a matter that may have escaped the attention of the writer. Then I wouldn't want to create a situation where I put somebody in a position where they are embarrassed. So maybe the best way to approach that situation is to go and talk to that person privately. But if it's something that has to be taken up and bank, Your Honor, then I would not hesitate to make known my opinion, but Your Honor, in a very respectful manner.
Are you unhappy in the Court of Appeals?
No, Your Honor, I
How
am
come
not.
you're applying in the Supreme Court?
Because, Your Honor, I feel that I can do a lot of things to help in the court at this point in the court's history and at this point where the court has all these opportunities to do a lot of things in terms of reform. Of course, we know that the court's function is not only adjudicative. The court also has administrative supervision over all lower courts and the court personnel, as well as over the members of the bar. And in this regard, I think that I'll be able to do a lot in terms of helping the court.
What horror stories have you heard about the Supreme Court?
Well, the docket, Your Honor. I know that there are a lot of cases, and of course, if you
Are you
are,
willing to forgo with socializing with people and spend countless hours and days poring over the cases assigned to you?
Your Honor, I really do not do much socializing. My case, my day in the Court of Appeals usually starts before 7 a.m. And if I have no classes in the evening, we usually stay, and we're the last to go.
Are you aware that there are 15 justices in the Supreme Court, and the only time you see them is on Monday during the flag ceremony, and on Tuesday during the en banc, and on Wednesday during the deliberation?
No, Your Honor, but I will note that.
All right. What is your understanding of surrogacy? Surrogate mother.
For mothers, Your Honor,
Yes,
surrogate mothers. Well, my understanding is that surrogate mothers are the ones who are physically, who accept the physical responsibility of bearing the child. When a female who is unable to reproduce wants to have a child.
It is also called motherhood by proxy. Is it legal in the Philippines?
I am not aware of any law that prohibits it in our country, Your Honor.
In cases of surrogacy, who is deemed to be the mother of the infant from the legal point of view?
The natural mother, Your Honor.
The woman who gave birth
Yes, Your Honor, the surrogate.
is the mother.
Yes, Your Honor.
And what about the donor of the fertilized egg implanted into the surrogate mother? What is her personality?
At birth of the child, Your Honor, no personality. Unless
She has no legal personality, you mean?
well, she has legal personality perhaps later on
Did
to,
she contribute
of course,
to
Your
the
Honor.
birth of the mother?
Yeah, not
To
to
the
the
birth of
birth,
the
but
child?
not to the birth, Your Honor, but to the conception. Without her egg, there would be no child.
And whose name should be reflected in the birth certificate of the infant as the mother?
Your Honor, the natural mother, Your Honor.
The natural mother.
Yes, Your Honor.
Supposing both the surrogate mother and the donor of the egg are working in government, who is entitled to maternity leave benefits?
The natural mother, Your Honor.
The surrogate mother who gave birth?
Yes, Your Honor. Because if I understand correctly, the rationale for that law is precisely because of what the natural
I'm
mother
sorry,
will undergo.
you said law? Is there a law that governs surrogacy now?
No, Your Honor. I thought you were referring to maternity leave. So I'm referring to the law that allows for maternity leave. So I think the intention behind that law is precisely to take into consideration the fact that she's going to give birth and she has to recover physically. And so it has to be the natural mother,
Will
Your Honor.
the sperm donor, the father, be entitled to paternity leave benefits, considering that they are not legally married?
I would have to answer no at this. Given the facts that you gave, Your Honor, I would have to answer no.
So the surrogate mother can avail of paternity
Yes,
leave
Your Honor.
benefits, but not the
The donor.
donor sperm
Yes, Your Honor.
father is
Yes,
not
Your-
entitled.
Yes, Your Honor.
What what is your understanding of gerrymandering?
Your Honor, well, it's when you take geographical portions of existing local governments, and then which are not adjacent to each other, and then by law you create a new district, legislative district, putting this not adjacent.
There was a law passed by Congress dividing Palawan into 3 provinces.
Yes,
Is
Your
this a form of gerrymandering?
No, Your Honor. No, Your Honor. The creation of additional districts in an existing local government is allowed under the law, conditioned on the satisfaction of certain requisites, I think, in regard to population and also in regard to income.
Can family courts decide questions on constitutionality of laws? Family courts.
Your Honor, can I distinguish? Are we talking about the family courts first designated when the Family Courts Act was enforced, or are we talking about the new family courts, which are created by law as family courts?
You can make the distinction.
Okay, because the first family courts, Your Honor, were really and originally regional trial courts of general jurisdiction. They were just specially designated to act in family matters. And so I believe that they still carried that original jurisdiction. And so they would have the original jurisdiction of every RTC. And so they would have that jurisdiction, Your Honor. But the new family courts created under the special law now are really created just to try family court matters. So these new family courts will not have that jurisdiction, Your Honor.
Do animals have legal rights under
Yes.
Philippine laws?
Under Philippine laws. I know that there are laws for the protection of animals, such that cruelty to animals are punishable. In particular, Your Honor, if I may cite, I just had a case which I decided, but maybe this was last year, which involved cruelty to animals.
Do women in the Philippines have more rights than men?
I do not believe so, Your Honor.
Why is it that in the Constitution it makes specific reference of protection of women? Do women belong to the minority or they belong to a special privileged class?
I do not believe so, Your Honor. The reason why that is provided for in the Constitution, I believe, is because of the culture that we have. Our history and our culture has treated women in a different way and not in an equal manner. And
Is
that
that
is
a
why.
fair classification, considering that you don't believe that women belong to the weaker sex, correct?
No,
They're
Your
not.
Honor.
And they're not even in the minority because it's
In terms of-
possible there are more women
That's
than men.
true, Your
in
Honor.
the
That's true, Your Honor. Even in law schools, the women already outnumber the men. But what my point is, Your Honor, that the way that society has treated women because of our culture and our history is a testament to the inequality. And that is why probably the framers of the Constitution thought it wise to include that provision in the Constitution.
Brunei passed a law several months ago imposing the death penalty for gay sex and for adultery. If a similar law is passed in the Philippines, will it be considered constitutional or unconstitutional?
Your Honor, I would have to say on those facts that you mentioned that there is some sort of unequal treatment there.
So will it be unconstitutional?
Yes, Your Honor, under the Equal Protection Clause.
If a woman makes a false claim in court that she is a victim of rape and sexual harassment, what is she liable of? False claim.
False claim in court under oath, Your Honor, then perjury, Your Honor.
Perjury.
And it could be false testimony also.
Should judges be ethical?
Of course, Your Honor.
If judges receive allowances from LGUs is that being ethical,
Your Honor, I will have to,
considering that LGUs have many cases in court?
I will have to say no, that is not unethical because this court has
It
already...
is not unethical.
Not unethical, Your Honor. It has already been passed upon by this court previously during the time of Chief Justice Puno. In fact, there was, I think, a circular that was issued or a memorandum that was issued to this effect. Also, I believe in the local government code, it is provided for that allowances can be given subject to budgetary limitations by the local governments to the prosecutors, to the public attorneys, and to the judges in their stations. And I do not believe, Your Honor, that giving allowances to our judges or our prosecutors will necessarily make them unethical because they can still decide their cases fairly and independently despite the fact that they receive allowances.
They can
from the
decide
local government.
cases clearly.
Yes, Your Honor, clearly too.
But why is it that justices of the Court of Appeals in Cebu and in Cagayan de Oro accept allowances from LGUs, but justices of the Court of Appeals in Manila do not?
I will have to confess I do not know why, Your Honor.
Are you saying that the justices in Manila are more ethical than the others?
No, Your Honor. I also stayed in Cagayan de Oro for 3 years, Your Honor, because that is part of my rotation. And like I said earlier, at this point where we have that the Supreme Court's position on that, I do not see that it is unethical, Your Honor, as long as the judges still fairly and independently act on their cases despite the receipt of the allowances.
All right, one last question. You really want to be in the Supreme Court? You won't change your mind?
Yes, Your Honor. Thank you.
All right, one last question. What is your understanding of a case of first impression? What is your understanding?
Okay, well, a case of first impression supposedly is something that has never come before the court. So it's a novel
Is
question.
it something you do not know about?
Maybe, Your Honor, because it's a case of first impression. Maybe
So
it's
is
not.
it something that the court can decide because you do not know anything about it?
Well, it not necessarily. There is always the benefit of learning from others, Your Honor. But I believe that when we speak of a case of first impression, it brings up a legal question that has not yet come before the court.
All right, thank you and good luck.
Thank you very much, Your Honor.
Thank you very much, Justice Tihan. Justice Singh,
Yes, Mr. Chair.
what is imaginative writing? How do you distinguish it from creative writing?
They're the same. They're the same, Mr. Chair. It used to be called imaginative writing in my time, but now they call it creative writing. So they have abolished that course that I took. Now it's called creative writing, Your Honor.
Have you applied it in your decision making?
The only way that I have had a use for that in my decision writing is that I tell very good. I give my facts in a very good narrative. People who have read my decisions always say that the way that I present the facts is very interesting. They can actually see the story unfold.
You do not create them. It is
No,
based
Your
on
Honor.
evidence.
No, Your Honor.
Okay. Have you read the internal rules of the Supreme Court?
Yes, Your Honor.
What would you want to suggest or recommend to be changed? Going to join the Supreme Court?
Yes, Your Honor. Your Honor, perhaps, I'm not so sure of this, Your Honor, but perhaps the agenda, in preparing the agenda, to segregate the administrative matters from the actual adjudicative matters, so that when there are deliberations on the basis of the agenda, it will be easier for the justices also.
That is already being done.
Okay, so I did not note that, Your Honor, in the internal rules. Anyway, Your Honor, maybe the other thing is the Your Honor, the summaries that are prepared, that are supposed to be prepared for the matters for deliberation, to be, I don't know exactly, I've not seen a single one, Your Honor, but perhaps to give more information, but not to be, considering the time that they have to review it, Your Honor, that it be pithy, it contain everything that the justice will need, but at the same time provide the points for arguments that the justice should read up on.
In the rules?
Because, Your Honor, I read, from my recollection of what I read, there is a description of what should be included in the summaries.
Earlier, you made a distinction between the new family courts and the regular courts designated as family courts. Is there a prohibition on the new family courts from taking on constitutional issues?
No, Your Honor, there is no
Why did you
prohibition.
make such distinction?
Because, Your Honor, the law that created them limited their jurisdiction to family court matters.
If there are constitutional issues regarding family laws, can they not tackle it?
Regarding family court matters, Your Honor, if I remember the wording correctly, matters arising from the relationship of husband and wife. So,
They are defined by laws. If
Yes,
there are
sir.
issues on that, constitutional issues on that, can they not rule on it?
I will maintain, Your Honor, my answer that because it is a special law and their jurisdiction is specific to matters arising from the relationships of a husband and wife and family matters, other family matters, property
cannot-
relations. Yes, Your Honor, I will maintain my answer.
The CTA is also a court of limited jurisdiction. So it is not allowed to rule on constitutional issues?
The Court of Tax Appeals, Your Honor?
Yes.
No, Your Honor.
They-
No. Yes, Your Honor, thank you.
What is your concept or understanding of the rule of law?
Well, the rule of law, Your Honor, is it maintains order in society. It is every person's obeisance to the Constitution and to all the laws of the land.
What are the 4 universally accepted principles of the rule of law?
I must confess that I do not know what those 4 are. I probably know them, Your Honor, but I do not know them as the 4 universally accepted accepted principles of the rule of law.
Okay. Last October 2, 2018, the Supreme Court came out with Administrative Matter number 18-0105 SC, creating the Judicial Integrity Board and the Corruption Prevention Investigation Office, or JIB. Does the Supreme Court have the power to create such a body?
Yes, Your Honor. Under the rulemaking power of the Supreme Court in the Constitution, Your Honor.
And appoint members
And appoint members, yes, Your Honor.
and give them salaries?
That, Your Honor, we will have to, because they will become civil servants, Your Honor. They will be, so the salaries and other benefits owing to them, we will have to ask for money, and they will have to be included in the salary structure of the courts. So I think as far as that is concerned, we need enabling legislation, Your Honor. Yes,
By Congress.
yes, Your Honor.
In San Francisco, CCTVs in public places were banned because they infringe on one's right to free speech and assembly, and they distinguish and track faces and they invade one's privacy, are the images captured by the CCTVs admissible as evidence because they enable search without search warrant?
I would have to say no, Your Honor.
Plain?
Well, I agree that they are in violation of persons' right to privacy. They are being recorded without their knowledge. The people may not be aware that there are CCTVs recording their actions.
You agree with the state of San Francisco that they be banned?
Not
In
in all.
the context of Filipinos.
Yes, not in all circumstances, Your Honor. Like, I know that we use CCTVs to monitor violations of traffic rules. So if there is a legitimate state interest and the public is notified of the action that is going to be taken by the government using the CCTVs, then I don't think there will be a violation because the right to privacy is not absolute.
In several states in the United States, abortion is prohibited when there is already a scientifically detected heartbeat. In the context of Philippine laws, what is your view on this? When does life begins? When does life begin? Suppose there is already a fertilization, but still no heartbeat is detected. Can abortion be allowed?
If I remember correctly, in the RH law case, Your Honor, which the Honorable Chair penned, the court left the determination of when life begins to the experts, to the medical experts. But the court did say that the Constitution itself accords equal protection to both the unborn child and the mother, and that we acknowledge also that it is upon conception when life starts or life begins. So Your Honor, that is my answer to the question.
Need not be a heartbeat.
There need not be a heartbeat, Your Honor.
You mentioned earlier that in the Court of Appeals, you participated in the decision where the condonation doctrine was raised. What was your position then?
Your Honor, we voted, the division where I was a member, the junior member, we voted to apply the condonation principle because the acts attributed to the former mayor were still covered.
Applied it.
Yes, Your Honor.
Okay. Can a court motu proprio, without any invocation by the respondent, apply it to a respondent favorably?
No, Your Honor.
The court cannot motu proprio.
Apply to a respondent who
Yes.
did not ask the court to apply it?
Yes.
I don't think so, Your Honor.
So it should be invoked.
Yes, Your Honor, it should be invoked.
That was my last question. Thank you very much.
Thank you very much, Mr. Chair.
Your Honors, Justice Singh is the last candidate to be interviewed this afternoon for today.
The public interview today is terminated, adjourned for tomorrow, for next month, Tuesday. Hilo na rin ako. jurisdiction over government-owned and controlled corporations?
The public officers constituting the government-owned and controlled corporations, Your Honor, yes.
Are you not going to make a distinction?
I would say, Your Honor, that, just a guess, Your Honor, I'm not sure of this, but those performing purely public functions and not proprietary functions.
How about the Boy Scout of the Philippines? As the ombudsman,
No, Your Honor.
power over the...
No, Your Honor, because I think the funds of the Boy Scout of the Philippines comes from private funds, donations.
Are you familiar with the decision of the Supreme Court regarding the John and the leader of the Boy Scout of the Philippines?
No, Your Honor.
No. It's already a Supreme Court decision. How about the Philippine Red Cross?
Same with the Boy Scout, Your Honor, because most of the funds going into the Red Cross are private funds or donations coming from.
It that the Boy Scout of the Philippines is BOCC with original charter.
I am not aware, Your Honor.
You're not aware,
I am a Cub Scout, but not a Boy Scout.
but you have not been informed of that.
Yes, Your Honor.
Mentioned the case of Socrates earlier. Can you repeat what is your understanding of Socrates' decision?
In that case, Your Honor, Socrates, Mayor Socrates, called by a petition for recall. Now, in the recall elections, Your Honor, Mayor Socrates contested the hackathon for filing a certificate of candidacy, saying that he's already completed his term and that is a continuation of his term. According to the Supreme Court, Your Honor, that no, it's not the case because there was a vacuum. And it was an involuntary vacuum because Socrates was recalled. There was a recall election, and during that gap, it is not considered a continuation of the term.
Are you familiar with the case of Senator Pimentel? Protest against his candidacy.
Right now, Your Honor.
Yes.
Yes, Your Honor. Yes, the Comelec ruled, Your Honor, in favor of.
That he can run
Yes, Your Honor.
for another term.
Yes, Your Honor.
It's not that a third term. Do you agree with the Comelec? If you will be appointed in the Supreme Court, in the Supreme Court, and the case was asked. Do you agree with the court?
As I've said,
Adam said, Comelec.
as I've said earlier, Your Honor, the decision is part of the legal system of the Philippines, and I have to follow it.
That's the decision of the Comelec. How about your personal opinion? Remember, Pimentel was elected in
Yes,
2007. He protested, but it was Senator Subiri who was proclaimed. He won he filed the protest, and Senator Pimentel won in 2011. 2011.
I don't think my personal opinion, Your Honor, will count because of that decision of the Supreme Court in Socrates versus Aguilar.
Is there a vacuum here?
Yes, Your Honor, there is a vacuum.
Uh,
And it's not an
Senator Subiri sat in the Senate.
Yes, Your Honor.
Oh, there was no vacuum.
During
He
that
was a
time,
de
Your
facto.
Honor, during that time,
Senator.
Your Honor, Senator Pimentel was not acting as a senator because of that. He lost accordingly on the basis of the elections that time, Your Honor. So there was an involuntary vacuum insofar as senator.
So but he assumed in 2011.
Yes, Your Honor.
He was serving the first term.
Just for a several months, Your Honor, he assumed.
So if he served for several months, he did not complete the first term. Is that your opinion on that?
I would say so, Your Honor. It's not a continuation of the term.
Why not?
It was involuntary on the part of, I think the reckoning word is, Your Honor, whether or not it's voluntary or involuntary. And the vacuum is involuntary in that case, Your Honor.
How do you distinguish a term from a tenure?
Your Honor, a term is fixed, while the tenure is the period by which a public official renders his service, Your Honor. If, for example, public official dies, Your Honor, that's the tenure. It is up to them.
So the service of Senator Pimentel during the first term was not a service of the term.
First term,
Yes,
he completed the first term, Your Honor.
completed. And
Yes,
then
sir.
he ran for re-election and he won.
Yes,
He
Your Honor.
served the second term.
Yes, Your Honor.
So can he run for a third term? Because you said he completed the first term and then he completed the second term. Can he run for the third term? That allowed under our Constitution.
He ran, but he lost, Your Honor, according to
Who lost?
si Pimentel as against Senator Subiri.
This last election.
This last election, Your Honor.
Third term. This is the third term. They're the winner.
Yes, Your Honor.
Oh.
It's a third term, Your Honor.
It's a third term. Okay. Let's take it against you. Just an opinion. Another situation. The House of Representatives, a former governor, was found guilty of grave misconduct by the Office of the Ombudsman. The case stemmed from an unauthorized contract that he entered into when he was still serving as a governor. Such, the Office of the Ombudsman ordered his dismissal from the service. The said dismissal order carried with it the accessory penalties of perpetual disqualification from holding public office, cancellation of eligibility, and forfeiture of retirement benefits. Congressman Jose moved for reconsideration of the ruling, but the Office of the Ombudsman denied the same. On motion, the Office of the Ombudsman, by the way, it became final. On motion, the Office of the Ombudsman ordered the Speaker of the House of Representatives to enforce the dismissal order against Congressman Jose. The Speaker refused, arguing that under the 1987 Constitution, there is nothing among its provision that authorizes the Ombudsman to discipline any member of Congress. Question: can the order of dismissal by the Office of the Ombudsman be implemented against Congressman Jose for an offense that he committed during his incumbency as a local elected official?
I don't think so, Your Honor, because the House of Representatives is independent body, Your Honor, just like judiciary and the office of the president.
Ruling that carried with it the accessory penalties of perpetual disqualification from holding public office.
The implementation on that perpetual absolute disqualification from holding public office.
Is it not the seat in Congress a public office?
But, Your Honor, if my memory serves me right, I think the implementing authority there would be the House of Representatives.
Yes, the office of the ombudsman ordered the speaker implement the decision.
If the Speaker will have to implement it for it, Your Honor, to push through. Otherwise, Your Honor, the Ombudsman will have to file a case against the Speaker.
You have been aware of the Rappler case?
Yes, Your Honor.
What is a PDR?
I think a PDR is security, Your Honor, by a holder, which is, he has the option either to sell or hold on to it, but it is not a certificate of ownership. And, Your Honor, he only gets dividends from an underlying share representing the PDR, Your Honor.
What is, when is a holder liable for tax?
Whenever he gets the dividends coming from the underlying share represented by the PDR, Your Honor.
How about the transfer? Taxable?
Yes, Your Honor, if there is a transfer and then there is a gain, if the holder chooses the option to sell his rights to the underlying share, Your Honor, I think it's taxable.
The rule on accumulation of profits or dividends in taxation. You will be handling cases, tax cases in the Supreme
If my
Court.
memory serves me right, Your Honor, I think in taxation you cannot hold on to at least 100% of the minimum paid up of the income, Your Honor, of the corporation, representing 100%. You can hold in excess of that, but it should be used for business purposes. And you have to show that it is for business purposes.
What are the two tests for that? But have you not heard of the Bardal formula? Tax cases
No more,
in the
Your
Court
Honor.
of Appeals.
No more, Your
But you have started the jurisdiction of the city.
Before, Your Honor, I
Before
was...
this interview?
No, Your Honor.
No. Because you will be handling cases decided by the PTA. Anyway, I will not go. Those will be all. Thank you very much.
Thank you, Your Honor.
Wala. Gusto mo pa?
Thank you, Justice Alameda. We
Patawag
wish
mo
you
si Chief. Patawag mo si Chief. Tony Gadula, we're just waiting for the Chief Justice.
To be interviewed next, Your Honors, is Dr. Jeremy Benigno I. Gatdula.
Good morning, Dean Gatdula, or which title do you prefer to be called by?
Well, hopefully justice, but for now, doctor's fine.
Be careful of what you wish for. That's a dangerous thing. Anyway, you have been in the academe for some time. What were your specialties as far as law subjects are concerned?
The specializations I had, or the focus of teaching that I had, proceeded from the work that I was actually doing I did a substantial amount of work on the World Trade Organization and ASEAN. And so it naturally flowed that a lot of my teaching would be on international law, economic law, trade law.
Okay, so how long have you been engaged in that kind of specialization?
Shortly after I graduated from Cambridge, I took up international law there and made a focus on economic law. I came back sometime around 2000, 2001, and then the Department of Trade was looking around for a new special counsel to advise them. The legal counsel they had at that time was outgoing, and fortuitously enough, or interestingly enough, it was later on Chief Justice Lourdes Sereno who was on the way out, and I was tasked to or asked to come in to fill in the vacancy.
All right. Previous to today, you have had no experience as a judge or a quasi judicial officer. All your life, you have been a bureaucrat or an academician. Will that be a correct characterization of your past in the law?
I would say more of a practicing lawyer who also happened to be teaching, and who would also be affiliated with the media because of the column that I would be writing with Business World. And so I think for my entire career, I'd be straddling almost all of those areas. And most of the time, I also would be asked to help government, particularly with the Department of Trade and also the Department of Foreign Affairs. So in a way, I would be having a foot, or I would be spending literally, for example, my days in academia one morning, and then in the afternoon in government, and then in business in some other parts of the day. It's, I think, a little bit of a unique experience I had, but that I think is the, if with all respect, I think a better characterization of my career.
Okay. If you were to join the Supreme Court as a member, what do you expect to do there? Will you involve yourself only with matters of international law, or will you also show interest in other areas of constitutional law?
I've always been, well, I have been teaching, my focus in teaching is in international law, but I have been working on constitutional areas, particularly in the matter of rights and also in civil liberties. I would think in all the areas of the Constitution, I would try to make myself useful. Definitely we have each other's focus or areas of expertise, but I think the duty of a Supreme Court Justice is really to be able to uphold the Constitution, and that's what I seek to do.
Okay. Okay, let me focus on that a little bit. You're aware of these two terms, judicial restraint and judicial activism. Will you acquaint us with what is your take on judicial activism first?
Well, I feel, in a word, it's undemocratic. That's the reason why I am not...
Undemocratic?
Yes, Your Honor.
Activism.
Judicial activism.
Why is that?
Well, the Constitution, I think, was drafted by the people in a certain way with a certain meaning. And I think the duty of the court is essentially to uphold whatever it is that the wisdom of the people at that time when the Constitution was being made, to be able to uphold it or push for it. I don't think, with all due respect to the member of the body that I hope to join, that it is not within the purview or their mandated duty to create something or legislate or dwell
Okay,
in policy.
maybe that answer suggests that you believe judicial activism infers that you depart from the letter of the Constitution. Is that your meaning?
Yes, Your Honor. Although I do, of course, realize that there are some words in the Constitution that are drafted or are meant to be, in a way, open to interpretation to a certain extent by the judiciary. But the judicial activism that I know of, the one that, for example, Chief Justice Rehnquist was frowning upon, is one wherein the judiciary is substituting its wisdom already rather than that of the wisdom of the legislature, which is the elected branch of government.
But is not the task, the primary task of Congress, the Supreme Court, the power of judicial review?
Yeah.
And if that task was to be fulfilled, the Supreme Court cannot be hampered by the letter of the law?
Your Honor, in terms of with regard to judicial review, well, first of all, there's a long history about that. When we're talking about due process, of course, it started first with essentially procedural due process, and through time it became expanded to including a power of judicial review to check on other branches of government. But with regard to the phrase that you uttered, and that is unhampered, I think, with all due respect, I have to disagree. There is a certain limitation built in the Constitution, either thematically, philosophically, and also with the words that are contained there. There was a very good lecture that was made by Dean Panganiban before the Philippine Judicial Academy, which I happen
No,
to...
I am asking your opinion, your view, not the opinion of Panganiban or any other jurist. I would like to know what you think about these things, and if we have the same understanding of these terms, because that is what we value in the court, independence.
I was about to say, I agree with that, and actually, a lot of the things that Dean Panganiban was uttering in that lecture, I have been
I
writing
would
about.
rather avoid referring to any other person. You should be an island when you join the court. And if you were to be an island, you should be an independent island. You should not be taking your signals from other people, especially those who have spoken.
Okay, I was about to say, Your Honor, sorry, that I had been writing a long time before on the downsides of judicial activism, and I had been writing and teaching and preaching for a long time on the merits of the judicial responsibility to stick to the theme,
No,
the
okay.
text. And
I get your drift. If you were to show or to insist that you are not that keen to going towards judicial activism, are you therefore a conservative?
Conservative.
Do we have the same understanding of these terms?
Conservative, sir, in the sense that I would like to uphold the text and what has been written in the Constitution. I believe that if there is a need to amend the Constitution or a modern need that needs to be addressed, it is better left to the people to directly revise the Constitution or the Congress to make the policy call rather than the court. There was something that, and I hope you don't mind because you mentioned not to utter names, but I've always agreed with what Chief Justice John Roberts once said in his own confirmation hearings. The Supreme Court is essentially a referee. Nobody's interested in the referee. So,
Okay, I do not like, it's not that I hate these people, no? I do not, I love them. But my whole point is knowing what are you? What are you going to contribute, the potential that you have for the court? Because the court right now is, well, it's a powerful institution. And I don't like to ever risk bringing you there if you cannot contribute to that power. I am sure that you are prepared for this. But you must be saying things that would reflect who you are and what you will be. Otherwise, you have no place there. Because you will only be a mouthpiece of somebody else whom we do not like, maybe, or agree with. Now, going back to what you said, undemocratic, I am very intrigued by that. What do you mean by undemocratic? Are you saying that judicial activism should have no part at all in a republican democracy like ours, especially if you have three departments of government?
I was talking of judicial activism in the more extreme sense. As I mentioned earlier, there are certain portions in the Constitution, like for example the Due Process Clause, the Equal Protection Clause, which lends itself to some sort of flexibility on the part of the judiciary. But I think that there are provisions there that are pointedly that needs to be carried out, precisely because the people, when they authored the Constitution, they meant it to be, they agreed to ratify it in a certain way. And I think and it would be undemocratic for 5 Supreme Court justices, because that would be a majority of a quorum, to overturn the will of the people or the will
Well,
of the
do not,
legislature.
I think your track is Bickel's theory of the Supreme Court being an unelected, counter-majoritarian institution. All right? But let's not go as deep as that. I am just interested to know if you were willing to read the intent more than the letter of the law. My understanding is that when you are a judicial activist, you are not going to respect the boundaries that you seem to see in the letter of the law, but you would rather go behind the law and determine the spirit, the intent of that law. That is all what judges should be, not to be literal about the law, but to be open-minded about the reason for that law, the spirit of that law. Are we in agreement as to that?
It pains me to say, Your Honor, I actually do not agree.
Okay. Now, do you understand the term bias? How do you understand it?
Lack of impartiality, as you mentioned, closing of the mind to a certain position, prejudice.
Prejudice. Will your understanding of bias bring you to close yourself to any idea that would probably suggest you were not objective or you were not neutral? Or you would not tend more towards one side rather than to the other side?
Your Honor, if I may answer it first in this particular way, I have been writing in my column for almost 12 years. And I have made particular public positions on certain issues on civil liberties and what have you. So therefore, I would have my biases as an advocate. But as a judge of the as a justice of the Supreme Court, my oath would be to uphold the Constitution, which is, I believe, would be in text. And then later on, if the text is not clear, then I would try to discern whatever it is the meaning of the people who drafted it wanted it to be.
Okay, is bias a bad word?
All of us, sir, have biases.
That's all.
Okay.
You are going to bring biases to the court if you were to be appointed?
Well, my bias would be for the Philippines. My bias would be for the Constitution.
That's very ideal of you, but will you agree with me if I said that the Constitution somehow contains articles or provisions that are replete with bias? Meaning requiring you to tend more towards one rather than the other
Yes, Your
side
Honor.
of a litigation?
Yes, Your Honor. There have been statements of principles, for example, on social justice, particularly also provisions with regard to poverty, with regard to the family, on women, indigenous peoples, and the like. There have been occasions when the Supreme Court said that, well, like for example, in the case of the prioritization of the budget for education.
So you would agree now that bias is part of the judicial task?
In the sense that to demonstrate bias in favor of what the Constitution.
So you may not be a fair judge because you now agree to an extent that you could be biased.
No, Your Honor, I am a fair judge because my duty as a judge exactly requires me to uphold what the Constitution says.
And what the Constitution says is you should be biased according to you when it comes to due process, when it comes to health, when it comes to so many other things, family, etc.
Depending on the exact provision, there are some provisions there that mentions health
So
as a.
if that is your answer, you could be biased one time and not biased at the other time. Is that always what you will be when you will be a justice of the Supreme Court? It's dangerous if you do not clarify that today and you get the appointment and suddenly you sit beside us in the court.
But Your Honor, there are certain provisions there that we know are not exactly executory but are merely exhortatory. And there are some provisions there that we know should be upheld, like freedom, rights.
Okay, you have a situation here, an appeal of an accused who claims he has been unjustly convicted, prosecuted, and tried. And yet, here comes the accused who says he is innocent. Are you not going to be biased in his favor? because the Constitution says he should be presumed innocent. And that is a mandate of the Bill of Rights. Why are you thinking? You should have a ready answer for that, because when you are a judge, you should be already alert quickly, because you have read the Constitution. You have imbibed a lot of jurisprudence. You have understood, as you have just said right now, that due process is a source of bias for you. Are you not ready to answer me now if you could be biased as a justice of the Supreme Court?
The presumption.
You should be biased.
The bias would be.
No, that's a problem that often confronts us. You know, bias is not necessarily a bad word. People who misunderstood it and misunderstand it have made it a bad word. You know, we are dictated by no less than the Constitution to be biased. And that should not disorient you or confuse you at all. Are you ready to be confused?
I think before, pero now I'm not. But no, but to answer your question, Your Honor, I took some time because obviously the bias would be the presumption of the innocence of the accused. But we are in the Supreme Court, so also the consideration is that there have been lower courts.
Let me give you this concept that I have in mind. That's why I am very curious about the thinking of people who contend for positions in the Supreme Court. There are many complicated cases, complex cases that go up to the court. Almost all deliberations deal with complicated issues. Is it possible for you to resolve or navigate your self, your mind, your thinking, if you did not have bias?
Well, actually, I agree with Your Honor. I actually call it compass. Either a professional or moral
No, I'm not
compass.
talking about compass. The compass that we know is that one that points to the north all the time, okay? The geographical north. But what I am talking about here is a complex case. It brings so many questions for consideration, for deliberation. If you do not know where to start, it is not easy for you to navigate your way through the complex issues. Somehow you must start with bias so that you will know where to start. At least resolve that particular starting point. That's my concept. So anyone who tells me you are a biased judge, I am. Because I cannot resolve any complex case without bias. You get my drift?
Yes, Your Honor. Actually,
All right. Let's go to the other concept. What do you understand by judicial restraint? Is that the opposite of judicial activism?
In a sense, Your Honor, yes, because the judiciary should not be exercising its power to the extent that it will be substituting its discretion or judgment, meaning policy, in the areas of policy, with regard to the other branches of government. One of the things that I have been pointing out to the public, and I have written before about this, is that people look at the qualifications of the Congress and they see how small or limited the qualifications that are required. Whereas with regard to the Supreme Court, what's required is that there be years of practice in law and the like. People think that because of that it tends to make the Supreme Court a more intelligent branch than the other two branches. And I've been pointing out that's not necessarily the case. Because the reason why the qualifications for the Supreme Court includes the legal degree is precisely because our function is essentially limited to looking at legal questions rather than political. Whereas the other two branches of government, the requirements are highly or utterly minimal, because it allows the people to be able to fill in as much variety as they can, so that in terms of policy making, most varied and different singing views can be made either in the legislation or in the implementation of the legislation.
Okay, when it comes to the issue of constitutionality of a law passed by Congress, there are two houses of Congress. We presume, we give the highest presumption of validity to this law because this was deliberated upon, discussed by the two houses of Congress, where we have the elected representatives of the people sit, their collective wisdom pass that law, what do you think is required if that issue is raised at all, a serious issue about the constitutionality of that law? Will you exercise judicial restraint or judicial activism?
Definitely restraint. Precisely because the unequal branch of government had put a lot of time and effort into coming up with this kind of legislation. Unless there's a real clear violation of the Constitution, that I would prefer that the Supreme Court exercises restraint.
So we will just dismiss immediately the petition that would challenge, because you would be thereby exercising judicial restraint.
Not immediately. I mean,
That's a dangerous stance that you tell me now.
not immediately, but you were mentioning bias earlier, Your
That's-
Honor, and my bias is essentially with regard to judicial restraint.
You're biased in favor of judicial restraint.
Yes, sir.
Oh, here is a question. You just told me that you would rather have that law maintained or upheld. You were very quick in
Yes,
your
sir.
answer.
Yes.
Does that justify your immediate dismissal of that petition that would challenge that law?
No, my answer was just quick, but in real life, what I would do is, again, study the case and give it the necessary time and deliberation. But
So under what circumstances would you nullify a law passed by the Congress whose collective wisdom is elective?
number one would be is the one that clearly violates the text of the law. Number two, if that there is a clear non-showing of a public use or or reasonable means with regard to the objective that the Congress wants to achieve. Save that, I would prefer to give this deference to the wisdom of Congress. Having said that, Your Honor, I do realize.
Well, you have heard of this. I'm not condemning them. I'm just parroting what I read often. Many members of Congress are scalawags, crooks. Now, do you trust their wisdom? I'm not saying that I believe that statement, but you also probably have read that statement. Will you now trust their wisdom? Will you now give them the presumption of validity as far as their collective wisdom is concerned? And you exercise now judicial restraint as far as their act is concerned? Is that what you mean?
I do not trust the scalawags, but I do trust the collective wisdom, because I think in the experience that we had in our country, it is highly rare for a law to come out utterly unwise or utterly malicious in content. Now, assuming that there could be some that could have some flaws constitutionally, that is why the Supreme Court is there to conduct the checks and balance necessary on Congress, precisely because they are human. They're going to commit mistakes in one form or another. The Supreme Court could also make mistakes. That's why ultimately for me, the supreme checks and balances is the people themselves. That ultimately by the act of suffrage or by a referendum, people could actually serve a check on government. I think, again, if I may mention a name, the Federalist Papers, James Madison, was very clear and very eloquent in writing about the better nature of men. But if men were angels, then no government is necessary.
Madison was over 400 years ago or 200?
Jesus is 2,000 years, but
We are not talking about religion here. We are talking about law, about justice, about membership in the Supreme Court, where we will be contending with these issues. That's the point that I am making. I do not like to pass you, that you pass muster, unless I can see that you are capable of fairness in the adjudicative process that we have in the Supreme Court. And many people are often asking, are you a justice who is going to be influenced by judicial activism, or a justice who will follow judicial restraint? These people who are asking are often people who do not understand the work that we have to put in. So that is why I wanted to know from you if you had the same understanding of these terms as I do. Now, judicial intervention in policy making, that is where you would need to discuss judicial restraint. Is that agreed?
Yes,
We
yes,
agree
Your-
on that?
Yes, Your Honor.
Now, the power of the Supreme Court of judicial review, as well as under the second paragraph of Section 1 of Article 8 of the Constitution, necessarily requires you to intervene in policy. So, if you were to answer my question now, are you one for judicial restraint all the time?
Restraint in relative terms, Your Honor. I was
No, when you exercise power, the power of judicial review and the power, the grave abuse clause.
one complexity that this Constitution gives everyone is the power of the Supreme Court to look on the nature of grave abuse of discretion, which necessarily would include areas of policy or areas that normally would be considered as a political question. My doctorate, my dissertation paper actually examined the limits of the judicial power with regard to this area of grave abuse of discretion.
Have you published that dissertation? Why don't you give us a copy? So that
I did,
you gave us a copy. All right. You are a doctor of laws, huh? Doctor, can you treat headache? Yes. Okay.
But my handwriting.
No. I think you are clear enough that you would rather be a judicially restrained jurist, no? Okay, but remember what I just told you about bias. Do not condemn that term, because bias is often misunderstood. And it is misunderstood because philosophers have given it a bad name. Judges sometimes and very frequently need to be biased in order to resolve complex issues. And anyway, the Constitution, just a parting comment on this, the Constitution itself dictates that you have to be biased. Do you agree with me?
Yeah, sure. Actually, if
The
I may.
Constitution says innocence is presumed. Is that not dictating bias in favor of one party?
Yes, Your Honor. In
Okay.
fact, I've
The
been
Constitution says favor labor. Is that not an expression of bias?
Yes, Your Honor.
Favor the environment. Is that not? So we are clear about where you stand.
Yes, sir. Actually, one of the things that I have been pondering about is with regard to the area of discrimination. The Constitution does not actually frown upon discrimination. It frowns upon unlawful discrimination. And the Constitution, I do agree with also, if I may say, the Constitution does a lot of discrimination as well, positive discrimination in favor of Filipinos, in favor of the young, in favor of the poor.
Don't call that discrimination. It's bias in favor of patriotism, nationalism, etc. Okay, Dr. Gadula, I have nothing more to ask you. I'll give the floor now to my colleagues here. And thank you for giving frank answers. I hope if you were appointed, you would be biased. Thank you.
Thank you, sir.
May I note the interpellation to Justice Tiham, and may I be allowed to leave?
Good morning, Dean Gardula, We gave you a written exams yesterday, and it was on the topic of same-sex marriage. And we completely forgot that you were one of the lead counsel in the Falsis case. So what is your, for the record, what again is your stand on same-sex marriage?
Um, Detached from the Falsis case, my stand on same-sex marriage, personally, not as a justice, but personally, I feel that it's not a valid definition of marriage. It is not contributory to the common good. I believe that marriage is not created by the state, but rather has been recognized by the state, and that marriage is between a man and a woman in comprehensive union, which same-sex marriage is not.
Is that more of a moral conviction or moral judgment on your part?
No, partly, but also because of the fact that history, sociologically, and philosophically, marriage has always been, in a way, defined that way. Even though, for example, the church may have a certain, the Catholic Church may have a certain stand on same-sex marriage, I have never actually relied on the teachings of the Catholic Church to defend my position on whether or not it would be better for the Philippines to stick to the traditional definition of marriage.
Now, as a judge, as a magistrate, as a justice of the Supreme Court, in deciding cases, should you be influenced by your moral convictions, your moral judgments?
Assuming that the provision that we're talking about leaves a certain room for interpretation or latitude for the judge, there's always a possibility that perhaps the judge may be called upon to make a judgment. Because there would be certain areas, like for example, if we're talking about on issues of incest, on issues, for example, of pornography, or issues of bestiality, there is always a moral component on those things. But if we're talking here of an express, clear text of the law, I think I would have to set aside whatever my moral convictions are and apply the law as it is written.
Now, with respect to the issue of same-sex marriage, is there a constitutional or legal basis for striking it down or upholding it?
Sorry, striking down same-sex marriage, huh?
Yes.
The difference kasi with the U.S. Constitution is that the Philippine Constitution contains several mentions of the word marriage, family, and children. And as I also pointed out with regard to the oral arguments on June 26, last year, when we look at the dictionary and any survey perhaps at that time, from the time that the Civil Code was made, and then also with regard to the Family Code and the 1987 Constitution, the belief of most people is that marriage has always been between a man and a woman. It is within that short time from 1987 to now that people have been open to the idea of marriage as between two people. But my position has always been that we interpret the Constitution, and I think that has been the belief of the Supreme Court in Francisco, and I think in civil liberties. We interpret the Constitution as it was meant or understood by the people at the time that they ratified it. And so I believe in 1987, people thought that marriage is between a man and a woman, and I think we will have to hopefully abide by that. Secondarily, the transcript of the Constitutional Commission also makes mention of certain discussions on marriage, and the implication is that it was always understood as being between a man and a woman.
Now, earlier, the Chief Justice made mention of certain biases enshrined in the Constitution, like protection in favor of women. Is that a reasonable bias? Are women, do they belong to the minority? Women constitute more than half, probably, of the population of the world.
I've actually...
Do women belong to the weaker sex?
No.
I think women will contest that assertion. So is that a bias? Is that an unreasonable bias? Why the Constitution should expressly state protection, a classification for women?
I've actually pondered upon that issue on why women have been given certain mentions constitutionally. But the period we're talking about here is sometime 1987, when I think professionally and politically, women have not achieved the same levels as they have right now. The Philippines right now is, I think, among the top 5 of giving women great responsibility politically and in business. But I think at the time that it was made in 1987, that certainly was not the case. There has been an amount of probably misogyny and sexism directed towards women. And I think a lot of it is coming out right now with the Me Too movement in the US. So I actually agree with what you mentioned about the fact that they constitute 50% of the population, and hence it makes us wonder why they're part of the minority. But perhaps also because of the fact that they are 50%, and then the behavior that has been exhibited upon them in the past. I remember, for example, in the 1950s, if you get to be if a woman becomes a secretary, a mere secretary in a corporation, that is already considered a big achievement. So there is perhaps a reason for that, but for now, at this present time, if we're talking of policy, I think it's something that needs to be revisited.
In case of ambiguity in the provision of the Constitution, and you are in the Supreme Court, you are tasked to interpret the Constitution. In case of ambiguity, is it necessary for you to refer to the journals of the Constitutional Commission?
My position, sir, is that, Your Honor, is that, again, and also looking at the past cases that the Supreme Court has made mention of this, Francisco, and I think the other one is Civil Liberties Union, the first instinct would not be to go to the journals of the Constitutional Commission, but rather to go to the what would be the normal understanding of the people directly at that time when they were looking at the
So
Constitution.
you would give more credence to what you perceive to be the understanding of the electorate who approve it, rather than the framers of the Constitution.
For the framers, probably as a support or subsidiary to that. And the reason being is that technically the author of the Constitution is not the Constitutional Commission, but rather the people themselves. So I think when they ratified it, they understood it in a certain way. And so I think that should be the one that's given deference.
Now let's talk about current events. Congress, there is a fight for speakership position in Congress. And there's talk about term sharing. Is that legally permissible? Is it constitutional to agree to term sharing? I mean, members of Congress, they serve for a period of 3 years. Now, under the terms sharing scheme, if there are three aspirants, they would be sharing 1 year term. Is that legally permissible and constitutional?
I think the Constitution does not expressly mention a specific term. We're talking about the Speaker, Your Honor?
Yes, only the speakership.
I think there is no...
Supposing Congressman Cayetano, Congressman Velasco, Congressman Gonzales, and Congressman Romualdez agree to a term sharing, and they put that in writing, is that legally enforceable? Is that legally permissible? Is that constitutional?
Several questions. Is it constitutional? My likely answer, of course, as usual, if you were in the Supreme Court, there will be greater deliberation on this. But right now, my likely answer would be, is it constitutional? The answer is yes. Because I don't think there's a prohibition in the Constitution that requires a speaker to be there for the entire 3 years. Now, whether that is a wise thing to do, I leave to the electorate. Because if it turns out that to divide the speakership terms into 3 makes the House of Representatives paralyzed and unable to do its duties, and I think the electorate will give a backlash on that one. The other question you ask, is it legally enforceable? I will have doubts on that one, because that entails a certain public position, and I think the position of the Supreme Court is that with regard to as a matter of contract, I don't think you can make a position the subject of a contract.
A written agreement among the aspirants, signed, sealed, and delivered, will that be considered binding upon Congress?
No, my answer there would be no, Your Honor.
That would still require the approval of the majority of Congress.
Yes, Your Honor.
All right, let's talk about protected speech. If media prints a statement calling the president a coward for not standing up against China or calling the president a mass murderer for the campaign against illegal drugs. Are those statements considered protected speech?
For the former, I would probably answer in the affirmative. I think we should be giving leeway to media in making its points in the way that it should be more accessible to the public. And I think the Supreme Court has always ruled that public officials should not have a thin skin and should be able to accept the criticism of what have you. My problem with the second question is that it makes mention of the word murderer, and that for me it's a technical term. And unless there is clear evidence and that would back up, that dangerously falls into the realm of being libelous.
In the reverse, supposing it's the president who calls media the purveyor of fake news, or he tells drug dealers deserve to die, is that covered by protected speech?
As I'm trying to find the correct word here, as interesting as those comments may be, I don't think, I think they would still fall under the purview of protected speech, Your Honor. Fake news, for example, is not a technical term. The other things that he's saying is essentially a feeling or emotion that this is something that should happen. It would be, I think, better left to the people, either by way of the midterm elections or electing his successor, to be able to show their approval on this one. It is possible that speech could be done in such a way, particularly if it involves a highly technical or legal meaning, that it could result in a violation of the Constitution, perhaps, and which would entail perhaps an impeachable offense, but that's highly unlikely, Your Honor.
You're in the academe as well. Harvard rescinded the admission of a student due to a racist slur or remark. If that same thing happens in the Philippines, will the act of the school be considered valid and legal? And if that constitutional issue is raised before the Supreme Court, how would you decide it?
The complications in that case, and you're talking, okay, Kyle Kashuv, is that, and I don't agree with it, because of the fact that I think a 16-year-old should be allowed to be stupid, and a person could grow, and a person could mature. But having said that, Harvard, being a private institution, would have the ability to make its own decisions on who to accept. So as objectionable as that decision may seem to me, I think Harvard is well within its rights and academic freedom to do so.
But here in the Philippines, if the same thing under the Philippine setting,
were it a private university, I would probably have to think of it in the same way. The complications would arise if it were a public university. And in our particular case also as well, perhaps what may adjust my answer with regard to the private university, the one I mentioned earlier, is the fact that racism is not such a hot topic or controversial topic here in the Philippines. One invokes racism here and you will not see burning cars or riots in the streets. One of the reasons why I think they are a little bit careful in the US is because even a hint of racism could result in broken windows and even serious injury to a lot of people.
what is the rate of habeas data? What is your understanding of the rate of habeas data?
I've heard about it before, Your Honor, but I'm not sorry.
If a politician is implicated by the president in alleged illegal drug activities, and his name is included in the so-called narco list, and he applies for a writ of habeas data, do you think that relief should be granted by the court?
I'm sorry, who's applying, sir, for the habeas
The
data?
politician whose name was implicated by the president into alleged illegal drug activities, and he is included in the so-called narco list, can he seek relief by applying for a writ of habeas data?
I would probably have to say yes, Your Honor, on that one, particularly also to be able to enforce his right to the right to be able to defend himself and also his presumption of innocence.
Now, one last question. The IAAF, International Association of Athletic Federation, disqualified an Olympic champion, Caster Semenya from South Africa, from participating in female competitions because she is biologically, according to the IAF, she is biologically male and she has to reduce her natural testosterone in order to compete as a female. They conducted this so-called gender verification test, and they applied the hormone rule, and they declared that she has more male hormones than female. It's a medical condition known as differences of sex development. People born with typical male XY chromosome pattern. Now, to be allowed to compete, the IAAF required that the affected athletes be required to medically reduce their testosterone level to below a specific threshold. Is that legally permissible? Would that be constitutional if under the Philippine setting? An Olympic champion, a female,
Yes.
but based on their gender identification test, it was revealed that she is biologically male, and therefore before she's allowed to compete in the female competition, she has to undergo certain requirements.
Your question is whether is it correct that she's not allowed to compete, or
Yes, also that. And then imposing certain requirements before she is allowed to compete.
I think with regard to the Philippine setting, we've had the I forgot the term, the inviolability of the gender or the immutability of the gender of the person. So if a person is born female, then that person is female and will be considered as such. So should she be allowed to compete? The answer is yes.
I think the rationale given by the IAAF, because there is undue advantage on the part of somebody who has more male testosterone in her body. I think that's the point.
But I think in the Philippine setting we have not, with regard to the second question, I think with regard to the Philippine setting we have not had such guidelines that would allow us to make a call on that one. And certainly to force her to do so, I think would be against her due process rights of life and liberty.
One last question. Is mandatory ROTC constitutional?
Well, I have written about it and I have been pushing for mandatory ROTC. But in direct answer to your question, the answer I think is yes. I think the state has the right to call upon the service of the youth. And there are also provisions in education wherein the youth are supposed to be fostered patriotism and also with regard to their overall well-being. So in the sense that there's no
To the best
violation.
of your recollection and research, why was it discontinued in the past?
There was a ruling before of the Supreme Court which actually granted constitutionality to the ROTC. It was discontinued in the past because of certain people who I think unfortunately got injured or had an unfortunate occurrence happen to them while undergoing the ROTC program. But I think overall, if that is then that would, I think the rationale for discontinuing it is a fallacy. If that would be the rationale, then the answer would be to ensure safeguards so for such unfortunate events to not happen again. But overall, the constitutionality of the thing, assuming that Congress thinks it's a wise thing to do in their discretion, I think such a law should be upheld.
All right. Thank you, Dean, and good luck.
Thank you, sir.
Thank you very much, Justice Judge Ilaw.
Thank you, Justice Mendoza, Chairperson of this council. Yes, good morning, Dean.
Thank you. I'm actually not a dean.
You're not a dean.
I'm a secretary at the School of Law and Governance.
But should they address you as a dean? You're a faculty secretary operations committee, School of Law and Governance, University of Asia and Pacific. And your credentials are too impressive, being an author of a book or books. But yet, I've seen that your application letter has grammatical error. Can I read? And I quote, I'm presently with the University of Asia and the Pacific School of Law and Governance as Operations Committee Secretary and Lecturer. That is your application letter. And which followed, attached is a copy of my full CV, my updated personal data sheet, and other requirements. Is this correct? Attached is with so many documents? Or rather, what? Is this the way your decisions and resolutions may be drafted and released if and when you're nominated and appointed as an Associate Justice of the Supreme Court? Because we in the Council, in our pursuit to improve the judiciary, we refuse to shortlist those who do not know these basic matters. And why should you be an exception?
Well, I may have to agree on that one. What I was doing, Your Honor, was that I was following the format of the applications letters that were presented in the online, and I didn't want to deviate too much from it. This is for me quite an important matter. So what I wanted to do was to essentially just try to be as conforming to what has been written on the online application form and not deviate too much. That is unfortunate, Your Honor, I will admit. But I think I have 12 years of writing my column in Business World, as well as all the papers that I've written before. And I think you could probably, if I may invite you to look at that writing, and if that writing still does not pass muster, then perhaps I should not be in the court. But I do plead that just for that one mistake, if ever it is a mistake, be taken against me.
Thank you. Not being simply apologetic, but yet that's observant. Why did you move from Sambeda to Aureliano? Considering that you graduated with honors in all schools, and the records show that you've been in Sambeda from what year? 19... That is in the College of Law. And again, and why did you transfer to Aureliano?
Simply put, I had a bad year. I mean, I had an off year. I missed the...
QPI? QPI?
Yes, by 0.1%.
Coming from what? Who was then your professor?
Actually, that's the thing. I had no failing grades in all the years I have been studying. It's just that when they averaged it, I missed it by 0.1%.
Let's look into your medical records. That May 6, 2019, 14 trace and blood chem, FBS, cholesterol high. And we're looking into the best and the most fitted physically and mentally applicant. And your medical certificate states that physically and mentally stable at the time of examination. How about subsequent findings? Do you consider yourself physically and mentally stable?
Yes, I'm not taking any maintenance medicines. I have been keeping up a physical routine almost regularly. I have no restrictions on diet, fortunately so far. So I would guess, I would say I'm in pretty good shape, thankfully.
Said, what is your weight now? No? 75.
75, a little bit, sorry, a little bit overweight. A little bit being defined as.
So it's not ideal, so apparently.
But I'm working on it, Your Honor.
Through diet, exercise?
Diet, exercise, I swim a lot, and my wife is a great cook and supportive of me, so we're hoping to.
Your wife, a government retiree, you stated in
Yeah.
your PDS?
Yes, she used to be with the Soldier and the DBP, and now she's teaching and has a business.
You attended the study of U.S. Institutes program in 2016. And, what did you learn there from that you could use in the Supreme Court if and when you're appointed?
Well, they gave us a rather deep appreciation of the background and fundamentals of the U.S. Constitution. And the more interesting thing there is that I was coming in as perhaps one of only 2 or 3 lawyers. And the rest of the class were all political theorists and political philosophers. So I was able to get a deeper appreciation for what de Tocqueville, for example, was saying, Madison, Jefferson, and all the others. And so that for me was a very useful experience, particularly in viewing the Constitution now. Our constitutional history, of course, is very much related to the U.S. Constitution. But I would also add, actually, that the program very generously gave me a set of funds to buy a huge amount of books, and I think that also is the more helpful one.
Your expertise is similarly on the international economic law and policy, am I correct?
Yes, that's what. If I may, Your Honor, I started out having a specialization on international economic law and policy, but a lot of my recent work, we do know right now that international trade is not one of the things that used to be in the headlines. So WTO used to be in the headlines from 95 to 2001, but right now it has been relegated back to the business pages. A lot of my work right now focuses on constitutional issues, particularly with regard to sex, whether that be on same-sex marriage, the RH law, and abortion, and also with regard to euthanasia.
And again, if and when you're appointed in the Supreme Court, you could be assigned cases involving complex issues in different fields of the law. How do you intend to resolve those cases outside of your expertise?
I have been, I think, reasonably working on a price to a very competent degree on the other areas of the Constitution. I may be focusing my teaching on international law, but I have been teaching as well and working as well on other areas of the Constitution. So, and that is actually the reason why I'm applying for the Supreme Court. Hopefully to contribute whatever it is that I may have gathered along the way with regard to the Constitution.
In your Facebook page, you openly post comments against the LGBT's fight for reforms in the church, school, laws, and daily lives. In fact, the questions and answers have been zeroed by Justice Tiham on these issues. But you did not include Q at LGBT without a Q. Do you know what is Q stand for?
Queer.
Okay.
And the reason why I did not is because I have to stop somewhere. Otherwise, the alphabet will be LGBT, T, Q, R, S, W. It will be too long. And so I just made a decision editorially to stop at LGBT.
So, in being an active in the Facebook about various issues, since you seem to speak on your mind at all times, is this not dangerous? Are you seemingly be good fit in the judiciary if and when you're appointed?
Yeah, actually, that's why I found it interesting that Chief Justice Bersamin was telling me about having an independent mind because nobody has not accused me of that so far. But But I'm working as an advocate for those public issues. So I think the question is, can I be a fair and impartial judge, assuming that I do get to be part of the Supreme Court? And I would be with high conviction, say the answer is yes. I could detach whatever religious or philosophical beliefs I have from what I feel and from what I have learned is what the Constitution provides. So I will have no hesitation in upholding the Constitution if that is what is being expressly provided for in that provision of law.
All right, we have here copies of your ITRs from 2015 to 2017, and your gross compensation in all 3 years seems to be stable in the modest side, which does not seem commensurate with your net worth. Could you kindly explain this to this council?
What happened there, Your Honor, is that we're talking here, I think, of the 3 years, right? But before that, I had a mortgage with the bank. I don't want to name it here if it's okay with you, or if you want me to.
You have to disclose it.
Okay, PS Bank. So, and PS Bank had a program wherein after 10 years of paying for that particular mortgage on the property, what they will do is they will return the entire premium back to you. And so that's the reason for the amount of money that you see.
And there's likewise a discrepancy in your cash deposits of almost triple in your PDS declaration, 900,000, vis-a-vis your 2018 SAL end, 350,000. Again, please explain this discrepancy.
My understanding with regard to the response for the 900,000 is that it included the investments. For the 300,000, my understanding was that it only meant the cash deposit. I may be wrong, but that's how I understood it, and that's why I did not include the investments in the SALN.
All right, to replying again, as an associate justice of the Supreme Court, what are your expectations in the Supreme Court?
It's for me the body which I feel that if I join, I will be able to provide the service that I feel that I could give the best for the country. I do believe that I'm coming in hopefully at the right time wherein we are faced with such crucial issues, not only politically but also socially. And I feel that my training hopefully could contribute to that. The fact that I'm not from the judiciary, I hope, provides a variation of views or a different set of views that could hopefully provide balance and a further balance to the court. And I hope to be able to contribute as well in making the court have greater respect and essentially inculcate in the people a greater respect also for the rule of law.
And what do you consider your most significant career accomplishment to date as a lawyer, a private practitioner, and member of the academy?
Well, definitely arguing before the Supreme Court is one of the things that I have been dreaming of since I was young. And so appearing before on oral arguments was a big deal for me. The other one is getting my doctorate. As one ages, one gets to feel a limitation of powers. When I got my LLM from Cambridge, I did so purely on my own sheer abilities. But getting the doctorate required help from a lot of friends, and knowing that I got help from those friends essentially was special to me. And so I would also consider that doctorate.
Cambridge.
Yeah, Cambridge was for my LLM, my master's.
Cambridge where?
England.
England. So that's Cambridge in Cubao. So, even in Provident Village. Anyway, and what is your most failure in life?
I'll probably quote Sinatra. There may be some, but too few to mention. So. In the end, I think I have been fortunate enough that whatever I did not get, Providence has provided me something better.
If you could start your career over again, what would you do differently?
I'd probably apply as a Formula One driver. And then, I'm just joking. But no, I don't think I'll change anything. I think I have been pretty much blessed in the way it has progressed. It's not, I wouldn't say it's normal actually. Some of the things I did are not some of the things that other lawyers my age or the lawyers before me have done. I have pretty much carved out my own career path, and I think I have pretty much carved out my own kind of law practice. And so I would have to say I'm just grateful for what happened. And in that gratitude, I would say I would not change anything.
And why leave such stature?
Sorry?
And why leave that stature? It's more greener in the other fields than in the judiciary.
Simply because I feel it's a duty that if I have the ability to be able to give more to my country, I will. It may sound idealistic, it may sound corny, but that's purely the reason I have.
Wow, corny, admittedly. And what have you done professionally that is an experience you will not want to repeat?
I really, there have been some unfortunate things that happened, but I think they all contributed to me being a better person. So I really cannot, I mean, I'm not trying to dodge the question, but I really cannot think of something right now that I feel is so traumatic or so bad that I would not be willing to repeat it. I think whatever bad thing happened to me is something that contributed to me also maturing as a person.
Alright, if and when you're appointed as an Associate Justice of the Supreme Court, what specific reforms will you undertake to make a substantial contribution not only to the benefit of the bench, bar, but to the private sector?
Right now I'm speaking as an outsider. Definitely there's a need for speedier trials. There's a need to hire more lawyers, particularly for the prosecution branch. There's a need also with regard to better legal education. But I would limit my answer to saying this, that if there's one thing I would like to contribute to the court, and that would be to have a consistent judicial theme and philosophy with regard to the rulings. And so that the bench and bar would be, in a way, see the predictability in which the court would go with regard to the Constitution and their rights. And I say this with all due respect because I also say this as a law student. There have been often times that there are too many exceptions to the general rule that the Supreme Court has been giving. And I do also know the complexity with which the Supreme Court approaches or is faced with. But if there is one thing I would like to strive is to be able to attain that consistency in judicial approach.
And who would you mention to be your role model in the judiciary?
Well, in terms of, well, the three of you. So, but Justice Natura has always been one of my heroes with regard to the Constitution. Isagani Cruz also because of writing. But if I may mention Ian Brownlee, who is an ad hoc judge of the International Court of Justice, and also Antonin Scalia of the U.S. Supreme Court.
All right, thank you. That was my last and final question. Good luck and to your journey.
Thank you, Your Honor.
Thank you very much, Judge Ilaw. Good noon.
Yes.
How do we call you? Not Din.
Actually, Your Honor, Gemma is fine.
Jerome.
Yeah.
But you wanted to be called Justice earlier.
Oh,
You
sana.
mentioned. Okay. What is your judicial philosophy, if I may ask? You answered that earlier, but I would just want to be clarified.
Really just to be able to uphold whatever it is that the Constitution provides, to be able to set aside one's personal feelings and beliefs, and ultimately just to uphold what the people believe or feel that is best for them.
What did you mean set aside your feelings or beliefs?
All of us have our backgrounds, philosophies, prejudices, our religious beliefs, and the like. But ultimately, as a judge, it boils down to what it is that the Constitution provides. And so, even though, for example, my religion may say certain things, but I would have to defer to whatever it is that the Constitution may say. And that's it, Your Honor.
You mentioned biases earlier. Can you expand on that further?
Well, we're talking here about a certain a slant towards a certain viewpoint. So the Constitution has a certain slant, for example, with regard to women, indigenous peoples, also with regard to human rights, also social justice, and that would be the bias I think that Chief Justice Bersamin and I were talking about.
Should you be appointed to the Supreme Court, will you bring those biases with you?
As I mentioned earlier, the bias that I would seek to uphold is whatever it is contained in the Constitution. I would strive, and I think I have been pondering enough, even before I sit before you, on what would be my own biases that I would be dutifully setting aside, assuming I get to be a member of the court.
So you're prepared to set them aside.
My own personal.
So you would be neutral or objective.
Yes, Your Honor.
You earlier mentioned that study the RH law. When does life begins, as far as you're concerned?
A conception, Your Honor.
Sure. In the United States, there were several states which adopted the law prohibiting abortion if there is already a heartbeat. In the context of the Philippine Constitution, what can you say about that?
Fine, Your Honor, but our concept of when life begins starts way before even the heartbeat. The moment that the zygote meets with the egg of the female, you immediately already have that new life that begins. A new DNA, an independent, distinct DNA, an entity has been created inside the woman the moment that the sperm and the egg has come together.
How do you determine that?
Science has told
Without the heartbeat.
No, but science has told us that, Your Honor, because of the fact that there is already a distinction between the mother and the fetus that is there. So even if, for example, it's just a dot, that dot is already generating its own life and its own sustenance. It may be dependent on the mother, but it is distinct from the mother. So the DNA of that dot, for example, would already be distinct from the DNA of the father and the mother. So we know that at that particular point, there's already a new life that began.
So the heartbeat is not a gauge.
It's actually a more liberal gauge because it starts a little bit. It starts far after than our own conception of when life began.
You are against gay marriage, am I correct?
Personally, yes, Your Honor.
Yes, yes. How about partnership?
And that's something I also wrote in the test. The problem with civil unions or partnerships is that, well, first of all, I don't think it is contributory to the common good. That's one. The second thing is that if you're going to create a civil union or civil partnership, then what's the basis for it? We know that for marriage, the basis is the comprehensive union of the man and woman. But for civil union, what would be the basis? And normally the answer by the LGBT lobby or those who are advocating for civil unions or partnerships is on emotional bond. But if you're talking of emotional bond, then why should we limit a civil union or partnership with only two homosexual couples? Why should we not extend the civil union or partnership to all other human relationships that have a emotional bond? So, for example, mere friendships between two individuals wherein no sex is happening, but because of the fact that they have a friendship, or between a mentor and a mentee, or between a father and a daughter, mothers, or between brothers and sisters, for purposes of being able to create certain property, welfare, and adoption rights, or what have you, why can't it be done to extend it to all those other human relationships? That, for me, is the flaw in the argumentation with regard to civil union and partnerships.
You do not, how do you consider them as, you mean to say you want to disregard their emotions?
No, Your Honor. What I'm saying is that, because right now, I mean, people are free to be able to form relationships in the form that they want. They could actually have a contract that will protect their family right, their property rights. They could essentially, the legal system, from the Bill of Rights to contract law to criminal law, essentially protects all citizens, whether it be heterosexual, homosexual. What they are asking for is a government recognition of their particular relationship. So my question in return is, but what's the basis for the recognition by the government of their particular relationship? Because there is no...
You mean to say they are already protected under our current laws?
Most of the things that they're asking for are actually protected already under current laws. There may be some revisions needed perhaps for adoption. Some revisions may be needed perhaps for SSS, GSIS, giving of benefits. But for a greater part of the rights, I think a lot of it is already covered by the Bill of Rights, the Civil Code, and the criminal law.
Is it not better if these laws are codified to protect them? Because they are also human beings.
But Your Honor, they are codified already. Number one, in the Bill of Rights, also in the Civil Code and in criminal law. We're talking here of a population that's probably between, generously, that's a population of around 5%. Most statistics will probably show a population of 1 to 2%. And so,
Should we not protect them?
But they are already protected, Your Honor. That's what I'm saying. The question is, why should the recognition and rights be additionally given to them over and above that has been given to other people? Now,
What are those benefits being given to them over and above what the ordinary human beings?
they're essentially asking for recognition with regard to employment, just in case that they do not get hired. They are asking for a setting aside or ignorance, for example, of free speech, or even with regard to religious rights in terms of employment, in terms of the academe, and what have you. It also presents, Your Honor, a problem of evidentiary means, because scientifically, when we're talking, for example, of homosexuality, we're talking here of something that's really within the subjective mind of a person. I mean, there's no blood that can be drawn, there's no skin or muscle tissue that can be taken to be able to indicate if a person is indeed claiming, is indeed a homosexual or not. So if, for example, you have a person that was turned away from a job application, there's no way for this person to prove that he is indeed a homosexual. We just have to take his word for it. And neither can the other person, the employer, be able to defend himself, because there's no way for him to be able to tell if that person is indeed a homosexual or not. That's why in the US, for example, there are certain problems that comes up with regard to labor law, because you have a person who claims to be a transgender and who is a woman trapped in a man's body, and later on that person would be found flirting with the women in the ladies' bathroom. And then when he was approached by HR, why was he doing that? His reply was, yes, I'm a woman trapped in a man's body, but I'm also a lesbian. So, I mean, how is it possible for us to be able to construct a legal system to be able to account for something that even the scientific community is having a difficulty with?
So your view is that it is only physical. How about their sexual orientation?
But again, that's subjective, Your Honor. Again, there's nothing prohibiting them from having that relationship, Your Honor. It's not criminal. The question is, should that desire, orientation, or attraction be recognized by the government, by the state?